no less a personality than the chairman of our CPC and our tax guru, Mr. Folorunsho Albert, or Mr. Albert Folorunsho, who is a managing consultant in Creston Pedabo. Those of us that were here would agree that he did justice to that topic. It was quite an insightful and interesting presentation, which elicited a lot of reactions, especially as it had to do with tax and our tax liabilities. The third presentation was titled Strategies for Dealing with Non-Performing Loans and Distressed Investment. And because this is an international conference, and in the real sense of the word, we had a presenter from the United Kingdom, Luke Tucker Harrison. He's a partner at Keaton Harrison LLP in the UK. And then last but not the least, we had a topic or a presentation on the resolution of banks and other financial institutions, that's OFIs, under the Banks and Other Financial Institutions Act 2020 and the NDIC Act 2023. So matters arising, we had a presentation from the head of legal or director of legal of NDIC, Mr. Kushimo Oladipo. Oh, I forgot to mention, so the chair of the first session was our former president, Dr. Abiodun Layonu, who is the managing partner of Abiodun Layonu & Co., and a distinguished insolvency practitioner, whilst the second session was ably chaired by Mr. Amechi Nsofo of Grant Thornton, London, or United Kingdom. So that's all we had for yesterday, and those of us that were here, you'd agree with me, we had an exciting and insightful time yesterday, and we're not looking out for anything less today. We have two interesting sessions, all packed with 8 presentations today, and we're hopeful that we're also going to have a great time today. One other interesting thing I must point out was that we ended yesterday, the last session ended at about 5 o'clock, and I had a look around the hall, bird's eye view, and I noticed that the hall was still packed. Not that because people were waiting for lunch, which we had late, but because the presentations were quite interesting, and the presenters were able to hold our attention and keep our attention. Because I also noticed that after the presentations, people left. People didn't necessarily wait for lunch. So one can argue that people were waiting for lunch. So I want to thank all the attendees that were here yesterday. Thank you for your patience. And also thank you for turning out today, this early, for today's sessions. I think we all deserve a round of applause. Thank you very much.
I'm sure you also agree with me that he deserves a round of applause. Please put your hands together for Dr. Dofia. Thank you. All right, we'll move straight into the first session for today, and it will be a very interesting discussion. It's a judicial roundtable, but I'll invite the coordinators up here to guide us through the session. We have Mr. Obina Akbuchuku, who is a senior partner at Allen and Melbourne. Please put your hands together for him. And also make welcome Mr. Richmond Idaho, who is the deputy manager, Mixter Africa. Please put your hands together for them as it's the session.
Good morning, ladies and gentlemen, and welcome to day 2 of the program. We'll just go straight. We have a well-packed session for you this morning. It's a discussion on judicial roundtable, and we have erudite and eminent personalities to do justice to this topic. First is a very, very revered Justice of the Court of Appeal, the Honorable Justice Oyekachi Otisi, and we also have Justice Alexander Uwoye, a very respected Justice of the Federal High Court, and we have Mr. Kabito Karamagi, an INSO fellow, and we equally have a judge from Zambia, Judge Kazembe Chenda, who will also be discussing the perspective from Zambia. And the session chair is Mrs. Boma Alabi ONSN. I will just go through their profile quickly. Justice Otisi obtained an LLB from University of Ife, now Bafin Awolowo University. Interestingly, Justice Otisi have gone through the whole gamut of legal practice. From being a seasoned legal practitioner, she was equal in academia and also served in an in-house role before being elevated as a judge of the High Court of Abia in 1998 and elevated to the Court of Appeal in 2012. She is currently the presiding justice of the Court of Appeal, Kaduna Division. Please, a round of applause for Honorable Justice Otisi.
We have our second speaker, Honorable Justice Alexander Owoye. He is a judge of the Federal High Court of Nigeria and a fellow of the Chartered Institute of Taxation of Nigeria. He started his legal career at the Zamfara State Ministry of Justice, where he did his National Youth Service. After that, he joined the law firm of Asholu, Anifaloba and Co., and later joined Bayojo and Co., and served as a research assistant justice of the Court of Appeal between 2018 and 2023. He was elevated to the Federal High Court, where he continues to contribute significantly to the development of jurisprudence in Nigeria. His areas of expertise and interest span taxation, dispute resolution, and corporate governance. Let's make welcome Honorable Justice Alexander Owoye.
Please put your hands together for them as they make their way to the stage. May we request our panelists to please take their spaces on the stage. This way, ma'am. Thank you.
My lords, thank you very much. For a detail of their profile, you can see that in page 37. So going straight, our next speaker, Mr. Kabito Garamagi, an INSO fellow.
Can I go through, please? Sorry.
He is a seasoned legal practitioner of over 2 decades of experience in corporate insolvency. Kabito is currently the managing partner of Ligmark Associates in Uganda. All the way from Uganda, he's here with us in flesh and blood. Kabito has had several experience in a number of matters in insolvency across not just Uganda, but equally East Africa. He's acted on very contentious matters for the government of Uganda on electricity consumption and distribution. Please, let's welcome Mr. Kabito Garamagi to the stage.
Our Justice Chenda Kazimbe. He is a judge court, Commercial Division, Zambia. He was appointed to the bench in December 2018. He previously served in private practice, specializing in corporate advisory and commercial dispute resolution. At the bar, he contributed to the Law Association of Zambia, including on the Law Reform Committee, the Lands Tribunal, and as a mentor. Since joining the judiciary, Judge Chenda's continuous legal education has included insolvency, competition law, intellectual property, pensions, insurance, and environmental protection. Let's welcome Justice Chenda Kazimbe, who will be joining us virtually.
Thank you. So the discussion will not be complete without having our session chair, a very, very senior and erudite senior advocate of Nigeria. She's right here with us, and our session chair is Mrs. Boma Alabi, OON, SAN, the managing partner of Primera Africa Legal. She is a seasoned advocate with several experience cutting across maritime, tax, mergers and acquisition, real estate infrastructure, construction, and so on and so forth. Interestingly, Mrs. Boma Alabi, SNON, was the first and only female president of the Commonwealth Lawyers Association. And she is a member of several boards and a good mentor to younger and practicing practitioners. I will hand over to our session chair right away to take justice from here. Thank you so much.
Thank you, Obina and Richmond. Good morning, distinguished delegates. It's such a pleasure and a privilege to be here with you this morning, chairing this session. I'm looking forward to learning as much as you are. We had some preliminary sessions with Milords and Milords from Zambia, and of course our colleague from Uganda, where we planned. I'm not going to say much more. I'm going to hand over to Milord Honorable Justice Onyekachi Otisi to start with her presentation. The plan is to hear from all our speakers, who will take about 20 minutes to deliver, following which we'll have an interactive session where you can ask your questions and we can take comments. So without further ado, Milord, over to you.
Thank you. Thank you very much. I would start by thanking BRIPAN for this invitation. It's always interesting to be part of your program. I think about 2 or 3 years ago. Thank you. Insolvency, corporate insolvency, may be understood as a condition in which a corporate body, usually a company, is unable to discharge its debts as they fall due. This cash flow insolvency definition is favored also by our courts and is in line with the provisions of Section 572 of the Companies and Allied Matters Act 2020, which provides that a solvent, if it's unable to settle debts exceeding 200,000 within 3 weeks of a statutory demand, or failure to settle, to execute rather, a judgment debt, whether in whole or in part, or of course the court is satisfied that the company cannot meet contingent or prospective liabilities. Insolvency law has become increasingly important in Nigeria's modern economy. It's not just about debt recovery. It determines how distressed companies, their creditors, and other stakeholders, such as employees, investors, interact when debts cannot be paid. Insolvency, therefore, is not just a financial condition. It has legal, economic, and social consequences. Formerly, insolvency law was punitive, treating failure to pay debts as a moral weakness or as downright fraudulent. The modern view now recognizes insolvency as a commercial condition with internal and external purposes. Internal purpose being to protect creditors collectively, distinguish viable businesses that are worth rescuing from non-viable businesses which are to be liquidated, and decriminalizing debt failure. External purposes can be understood to be protecting employees and communities dependent on the distressed business, preserving trust in the financial system, and avoiding what I would describe as zombie companies that simply drain economic resources. CAMA 2020 reflects the current perspective of insolvency by providing both liquidation and rescue mechanisms. The insolvency toolkit in CAMA 2020 can be described as, well, fairly comprehensive and can be classed into three categories. First is the rescue and restructuring tools, which are early intervention tools aimed at preserving the company as a going concern. Under this tool, you have the schemes of arrangement. This is a compromise between the company and its creditors, members, or debenture holders to restructure rights and obligations. These schemes sometimes could involve a merger between two or more companies. You have the company voluntary arrangement, the CVA. This is a debtor in possession rescue tool which allows restructuring of debts or reorganization without liquidation. A proposal is made by directors, administrator, or liquidator, and an insolvency practitioner is nominated to act as administrator. It is a debtor-led restructuring tool with creditor approval. Thirdly, you have the administration. This is a corporate rescue mechanism where control is transferred to an independent administrator. And the court may order administration if the company is likely to become insolvent, and administration may achieve the statutory purposes. Basically, the appointment of the administrator is aimed at rescuing the company or to achieve better creditor returns. The next category is the creditor-driven mechanisms, which allow secured creditors to enforce rights. Secured creditors appoint a receiver manager to realize assets. It may be initiated outside the courtroom under a debenture security instrument or by order of court, if powers are not explicitly granted. Courts still play a role in appointments and supervision. Third category is the collective liquidation tools, which ensure orderly realization and distribution of assets, basically by winding up of the company. This is a terminal process whereby the company is dissolved and assets are distributed under court supervision. This may be voluntary, by order of court, or under court supervision. Now, in all these tools, the court plays a central and indispensable role. I would go into four main aspects of what the court can do, or does rather. First, as acting as a gatekeeper, ensuring that statutory thresholds are met, approving schemes, sanctioning liquidations, validating creditor claims. Court acts as a supervisor, overseeing and monitoring administrators, liquidators, and insolvency practitioners, and formally dissolving the company if need be. Court acts as adjudicator, resolving disputes between creditors, debtors, shareholders, and other stakeholders. Court acts as legitimator, conferring legal authority on restructuring, bring fairness and legal certainty. In all these tools, legal certainty, in all these tools, the court plays this role centrally, and it is indispensable. However, there are challenges. The jurisdiction of the over insolvency matters is domiciled in the Federal High Court, with appeals to are also entertained by the same trial courts and appellate courts. The result is that there are delays in dispensing with insolvency matters or disputes and inefficiencies, resultant inefficiencies, which make the insolvency process slow and costly. According to a World Bank data, average resolution time of insolvency disputes in Nigeria is 2 years. Cost at the end is 22% of the estate. Record only 27.8 cents per dollar. If you compare this data with that from some other similar jurisdictions, you find that Nigeria underperforms. The question we need to consider is whether the use of alternative dispute resolution in settling or resolving insolvency disputes or matters can help improve on these statistics. ADR, especially mediation, is being promoted in Nigeria's judiciary, both in the trial courts and in the appellate courts. In fact, the Court of Appeal operates a mediation center, which was established under the Court of Appeal ADR program, provided for under Order 16 of the 2021 Court of Appeal rules. Rule 7A of the Court of Appeal ADR rules does not expressly mention insolvency disputes. Specifically, matters relating to breach of contract, liquidated money demand, matrimonial causes, child custody, parental actions, inheritance, chieftaincy, or personal actions in tort. But then it now adds, or such other matters as may be mutually agreed by the parties. The qualifying phrase, as may be mutually agreed by the parties, leaves room for inclusion of insolvency-related disputes, but only where the parties consent to the referral. Participation is voluntary and the process is confidential. In my candid view, the mutuality as insolvency implicates wider creditor and beyond the immediate. The Court of Appeal rules, the ADR must be concluded within 60 days with a possible extension of limits for filing briefs in the appeal is suspended while ADR proceedings are ongoing, demonstrating that there is support in the legal framework for this approach. However, a germane question borders, to my mind, on the propriety of ADR or mediation or any other form of ADR in resolving insolvency disputes at the trial court and whether such resolution is appropriate on appeal. Many insolvency, and I say this because many insolvency proceedings require court sanction. For example, the scheme of arrangement, CVA proposals, nominees, winding up, we've already talked about that. And insolvency practitioners who are appointed as nominees in a CVA or as administrators act as officers of the court, whether or not they are appointed by the court. So their duties are to the creditor and the public. And these duties may not fit into private settlements. So would ADR really help? Bearing these arguments in mind, I would advocate the consideration of mediation by the parties before the gateway or supervisory roles of the courts are engaged. For example, before application is made to the court for an endorsement of any rescue and restructuring tool, any early intervention tool, which includes the scheme of arrangements, CVA, voluntary administration, or any creditor-driven mechanism is submitted to the court, the parties, guided by insolvency practitioners, should explore mediation to reach agreement on all contentious issues. This would go a long way to douse or downplay tensions normally associated with insolvency disputes and remove delays that may arise from prolonged litigation, as well as reduce costs. In a nutshell, ADR, such as mediation, can be useful in pre-insolvency and restructuring contexts, which is in negotiating repayment plans, debt restructuring, or CVAs. It can reduce the adversarial tension between creditors and debtors, may reduce litigation delays if used alongside formal insolvency processes, and reduce the overall cost of insolvency proceedings. Some other jurisdictions have blended successfully ADR and insolvency, particularly in settling pre-insolvency issues with a view to rescuing and restructuring ailing companies. Nigeria can borrow lessons, but must adapt to local institutional capacity. I want to conclude by observing that Nigeria's insolvency law is to a large extent statutorily comprehensive, but it is procedurally weak because there's the overall reliance on already overburdened courts. Courts remain central, but cannot be displaced. Courts remain central and cannot be displaced in insolvency, but ADR could complement them in appropriate contexts. I would strongly recommend, one, that ADR be used for pre-insolvency negotiations and restructuring. Two, while the courts be for legitimizing, supervising, and enforcing outcomes. And thirdly, I would advocate there should be a policy direction in this regard. I believe that with clear rules and maintaining professional standards, BRIPAN is in a good position to advise or guide on how ADR can be integrated into insolvency resolutions. If this is achieved, Nigeria can build a more efficient, credible, and economically resilient insolvency system, making it more attractive to investors. Thank you for listening.
Thank you. Thank you, my Lord. I think you'll all agree with me that that was really insightful and a good start. Insolvency is a commercial condition. Just a lot that we've learned. And my Lord, thank you for keeping within the time. We're going to go on now to hear from Honorable Justice Alexander Owoye of the Federal High Court. My Lord, you have 20 minutes. Please.
Let me use this medium to also thank BRIPAN for the invitation to come here. It's my first, and I'll try as much as possible to one or few words. The topic is reappraising the role of Nigerian courts in promoting corporate rescue. In the paper, I have said that in modern times, a company experiencing financial crisis, some measure of respite via deployment of compromises and rescue arrangements. Prior to the passing into law of the Companies and Allied Matters Act 2020, company insolvent rescue could basically be achieved in three ways, depending on the circumstances, namely, out-of-court resolution and informal workout. This is the company with our major creditors with the support of experts consensually brokered out to deal with debt issues. B, arrangements, schemes of arrangements, a process usually initiated by the company or two companies with support from experts. It's a regulated process, usually involving the Securities and Exchange Commission. The courts are also involved in terms of court-ordered meetings and other administrative compliance. C, receivership and management is a situation where restructuring and insolvency expert will be appointed by a secured creditor, lender, or trustee with a mandate to recover indebtedness from the company pursuant to contract, creating a security and right of assets realization or control over the business of the debtor company. In this latter situation, there is usually a conflict or tension between debt recovery and business recovery, and irrespective of the title of receiver manager, it is truly by the fruits of this professional that you shall know whether he's acting as debt recovery agent or is trying to manage or create a better value. And irrespective of the title of receiver manager, it is truly by the fruits of this professional that you shall know whether he's acting as debt recovery agent or is trying to manage and create a better value or outcome outside a simple liquidation or realization, sale of assets. Receivership is not perceived as a collective procedure or process, though, as we will note under the New Companies and Allied Matters Act, the legislature seems to insist that receiver manager should act as an administrator. Upon passing into law of the Companies and Matters Act 2020, two new rescue processes procedures were introduced in addition to the earlier three. They are the Company Voluntary Arrangement, CVA, and Administration. To this paper, I shall limit myself to the role of Nigerian courts in the making of company voluntary agreements as a tool for corporate rescue. Company voluntary agreements are a form of business rescue arrangements which allows a company in financial difficulties to propose a contract agreement to its creditors for the repayment of all or part of its debts over an agreed period. It is therefore a procedure to be adopted to structure debt repayment plans for its creditors. Under Section 43, Sub 1, 2020, directors of a company may make a proposal under this part to its creditors for a composition in satisfaction of his debts or scheme of arrangement of his affairs. Where a company is already under administration is being wound up, the administrator or liquidator may make a proposal to the company's creditors for a composition in satisfaction of his debts or a scheme of arrangement of his affairs. Under Section 434, Sub 2020, a proposal made under this part is one which provides for some persons called the nominee to act in relation to the voluntary agreement, either as trustee or otherwise, for the purpose of supervising its implementation, and the nominee shall be a person who is qualified to act as an insolvency practitioner in relation to the company. The role of Nigerian courts in company voluntary arrangement arises where the nominee appointed to supervise its implementation is not the liquidator administrator. In such circumstances, the nominee shall within 28 days or such longer period as the court may allow, after he is given notice of proposal for a voluntary agreement, submit a report to the court stating whether in his opinion meetings of the company or its creditor should be summoned to consider the proposal, and B, if in his opinion such meetings should be summoned, date on which and time at which he proposes the meetings to be held. Now, the jurisdiction conferred on the court at this stage is to order that the meeting proposed by the nominee be summoned and held on the date and the time and place at which he proposes the meeting to be held. The role of the court at this point cannot be extended beyond this because the law is that judges have no duty and indeed no power to expand jurisdiction conferred on them, but they have a duty and indeed jurisdiction to expand conferred on them. The court also has a role to play where the nominee appointed fails to submit requisite report to the court. Where this situation arises, the person who intends to make a proposal for company voluntary arrangement may make an application to the court in that regard. The law is that he who makes an application to court seeks an exercise of court's discretion, must therefore place sufficient materials before it to enable it to exercise discretion judicially and judiciously. In this circumstance, the court must be satisfied that directors of the company have made a proposal to it, that is, the creditors, for a composition in satisfaction with his debts or a scheme of his affairs. The court must also be satisfied that a nominee has been appointed and that the nominee has failed to submit the requisite report to the court, where the court is satisfied that materials placed before it, the company may direct the nominee be replaced by another person qualified to act as an insolvency practitioner in relation to the company. Now, they need to make the application to the court under Section 435(4), arises where the nominee appointed by the directors failed to submit the report. This is because where the nominee fails to submit the requisite report within 28 days after he has given notice of proposal for a voluntary agreement, he can make an application to court to enlarge time for the purpose of so doing. While this is not stated in exact terms, it is implied in Section 435 sub 2 of CAMA, which provides as follows: the nominee shall within 28 days or longer period as the court may allow. It follows that a court of law has the power to enlarge the time within which the nominee may submit the report contemplated under Section 435 sub 4. When an application is made to the court that the nominee has failed to submit the report required under Section 435 sub 2, the court may only exercise its discretion to direct replacement of nominee, where it is satisfied that there is no pending application seeking to enlarge time within which the appointed nominee may submit the report. Now, when the court-ordered meetings have been held and it turns out that the decision taken by creditors' meeting is different from that taken at the meeting held by the company, a member of the company may do an application to the court in that regard. As such an application is made, the court may order the decision of the company meeting to have effect instead of the decision of the creditors' meeting. The court may also make such order as it deems fit. Such order which the court may make extends to where the company is being held up or is in administration. The court may order stay of all proceedings in up. The court may also order the appointment of the administrator to cease to have effect. The court may also give such directions with respect to the conduct of winding up or administration as it considers it appropriate to facilitate implementation of its order, that the decision of the company meeting should have effect instead of the decision of the creditors meeting on the voluntary agreement. Other roles which the court plays in the promotion of corporate rescue in respect of company voluntary arrangement arises where a person entitled to vote in either the company's meeting or the creditors' meeting, the liquidator or administrator challenges the effect given to the decision taken at the meetings on the ground that the voluntary agreement unfairly prejudices the interest of a creditor, member of the company, or that there has been some material irregularity at or in relation to either of the meetings. But also the role where it is found that an officer of the company makes a false representation for the purpose of obtaining approval of members or creditors of a company to a proposal for a voluntary agreement. Section 441, 1 and 2 of CAMA provides that this constitutes an offense. When it is found to have done so, it is liable to be convicted and sentenced to a prison term, 1 year or fine as the court may deem fit, or both. Premised on the foregoing, I have stated that essentially the role of Nigerian courts in corporate rescue, particularly under company voluntary agreements, is to ensure that the measures authorized by law, in this case the provisions of the Companies and Other Matters Act, are adhered with. It is only when this happens that justice can be kept pure. Nigerian businesses will also be better for it, as all hands are kept on deck to ensure that Nigerian businesses are built to last. In conclusion, permit me to note that matters that have to do with businesses are usually time sensitive. I therefore recommend a synergy between BRIPAN and the judiciary that will see to the making of rules of court or practice directions that will put matters bordering on corporate rescue on fast track. I also recommend special insolvency training for Nigerian judges on the intricacies involved in corporate rescue mechanisms. Thank you for listening.
we can all do a little better than this. My Lord, we're really grateful. And I'm sure BRIPAN has taken note of my Lord's recommendation. A practice direction is definitely necessary. It will help and expedite matters. So I'm glad that the judiciary is actually putting that on the table, and I've no doubt that BRIPAN has taken notice. And it is also for teachers that we have the president of the bar in the room. I can see my president there. Mazi. Good morning. So we'll now be moving to Uganda, to our colleague, Mr. Kabito Karamagi. Firstly, let me say welcome to Nigeria. And we'll hand over to you now to speak to us about cross-border insolvency, strategies for engendering judicial cooperation and assistance, no doubt from the Ugandan perspective. Please go ahead. You have 20 minutes.
Hello, good morning. I'm delighted to be here. Thank you for the invitation, BRIPAN. It's the third time I've been asked to speak to you. I'm very much Nigerian right now. In fact, I demand a name. And I've been thinking of some of these names. I thought about maybe Amoachi and so forth. I said, no. Those are too many. One Amoachi and so forth is too much. I can't be a Baba Tunde, Baba Jide, because where I come from, Baba means father. Father of Tunde. So I don't have any child called Tunde. I don't, Emeka, now Emeka, where I come from means how much. You see, I'm not a commodity. You see? I thought about Akitunde. I said, but Akitunde means let's sell it. So guys, but I think Bola Tinubu looks good on me. So thank you very much for this invitation. I'm delighted to share my experience. My topic today is cross-border insolvency strategies for engendering judicial cooperation and assistance. And I want to talk about a practical problem that I handled back home in Uganda. Now, the cross-border insolvency the world over will kind of come down to an agreement that the legislative framework to be used is the model, ancestral model law. That's what is being adopted more, and it became more predominant after the 2007-2008 financial meltdown. It's that triggered everybody to think a little more closely, because as Lehman Brothers was going down and all the other companies were going down, no one had really given that much thought to the fact that these were global entities spanning all over the continent, all over the globe, and therefore subject to different forms of legislative frameworks in the jurisdictions that they're operating in. So in the advent of the meltdown, everyone was running to grab what they could, and those that were a little more orderly were kind of thinking, so how do we do it? And that's how this ancestral model law comes into focus. Now, as important as it is, and especially for the fact that we are growing, even Africans. I mean, look at me. It's the third time I'm here and I'm now called Tinibu. Trade across the continent is increasing. It's increasing. We have Nigerian banks in Uganda. Guarantee, UBA, others have come and failed. Global Trust Bank, PHB Group, and so on and so forth. What are they doing in Uganda? They are following business. So what happens if any of the businesses that they're investing in goes bust? We better be ready for this sort of thing. And as trade across Africa increases around the world, so are the risks of insolvency and cross-border insolvencies. Now, unfortunately for Africa, only half of the countries on the continent have embraced the model law. The model law is not meant for you to absorb it in whole. Just tweak it to fit. It's just not even meant to change the substantive law you have. It just embeds itself into your framework to allow for a more coordinated approach to cross-border insolvencies, coordinated cooperation, because when those are lacking, there's chaos. There's chaos. So in East Africa, only Uganda and Kenya have adopted the model law. Uganda did that in 2011, so we'll be celebrating 14 years, I think. We did 14 in August, so that's us. Kenya only came on board in 2015. But even when we did in Uganda, there was a little problem. There was a small provision here that talked about reciprocity, that it will only apply when there's a reciprocal arrangement. So it was pretty much like giving with the left hand and taking out with the right. So for a long time, then the law was just used. So only until 2022 that anomaly was absorbed. Now, in the case study that I want to talk about, this is what we had to do, because there was still the problem of reciprocity, and there was no instrument in place. The company Spencon Service, I hope you had time to watch the clip that I sent, because it would give you a better perspective. The company in issue was a conglomerate. It was a big-sized company in the East African region. Initially, started in Kenya, it grew into Uganda, went down to Zambia and Tanzania, and from my recollection, they were also trying to do something in Rwanda. And they had also established a holding company in Mauritius. Do we have these sorts of things here? Do we have these sort of frameworks here? So you see, that's cross-border business. For this company, at the time it went down, first of all, in Uganda, it had built the Ministry of Health. It had probably built about 10 hospitals in the 30 years of its operation in Uganda. It had done roads. By the time it went back and I was appointed as receiver, the company had just completed the dam. It had a 70 or 80 kilometer road to do. And so those were my first immediate challenges to address. In Tanzania, it had some projects going on, funded by Ugandan banks to the tune of about $100 million. So you can see already the complexity, all right? What happens? So we are appointed, I was appointed by one of the banks. There were 4 banks involved, three banks, 3 big banks in the country. The one that appointed me went bust. It had a bank, you can see. So this was one of the biggest exposures for the bank. So because of its extended challenges, the bank went bust. Anyway, that's a story for another day. But here, to go on to the main, company has several subsidiaries, of course. Some in the company that own that and own that, the other. So this is all this complex structure that we tended to think is only out there, but it also lives with us. It's actually there. So when we are appointed, it then evidence comes to light that there has been massive asset stripping of the company in the 12 months. significant asset stripping, significant fraud. And when we do that, what do the directors in Kenya do? They start bank administration proceedings and try to register that in Uganda. So for the secured lenders, this smelt a rat. They want to stop the receiver from digging up stuff. So unfortunately, from this point, suspicion, mistrust ruled the day. So there was, as the director, the administrators came to try and get to get recognized under the Act, there were challenges. One, do you remember I told you the law? There was no reciprocal arrangement. The other, the suspicion of the creditors. Do not allow it to happen. And smelly was that they had not done anything in Zambia, probably because of law business, but in Tanzania, they did not allow for that to happen because the law, they hadn't adopted the border law. So it looked like Uganda's assets were the target. Now, the other challenge we found were the number of professionals involved. There were 3 banks, each with their lawyers. There were the administrators who had come with their lawyers. And then there were auditor and accountants speaking numbers and figures. So suddenly the banks also had to bring in their numbers and figures guys. So, and egos started flying all over the place. But it soon came to our knowledge that what they had done in Uganda, the directors had done in Uganda, they had done in Kenya too. In fact, there it was the misuse was far more glaring. As the company had gone down, was going down in its difficulty, guess what the directors had done? They had decided to build a golf course. And they had bought top-range cars and so on. So there, the workers actually went on strike. And what did the directors do? They fled, went off to Europe. Now, the assets in Uganda not only included land and so on, but there were claims from government, unpaid monies from government, from several projects. But that was not enough, unfortunately, to settle the secured lenders alone. So in other words, the unsecured, that was a loss. So because of the assets that had been sold at significant undervalues, some for as little as 5 to 10%, monies from those were actually not put on the company's account, but on an individual's account, and then money disappeared. This individual then went back to Kenya. So that's the sort of thing we had to deal with. And we had to think of, okay, one more challenge that we had, that while we had all the information, you know, the claims and the assets in Uganda, there were just also as many claims in terms of suits that were filed against the company and evidence of fraud, but it was being controlled in Kenya, on the servers in Kenya. So what the administrators there had done was first switch off Uganda. And we first said, so now, we had a challenge with the law, we had a practicality. We had to cooperate somehow amid this suspicion. So how did we resolve this issue? The solution was in entering what you call a consent judgment. Do you have something like that here? There you say, okay, we respect the law and what have you, practicality and pragmatism demands that we give you what you want. We will recognize you, but you will not touch any of the assets in Uganda. Those are exclusively to be managed by the receivers in Uganda because they had started the process of enforcement before, and your own appointment kind of comes off smelly. So that was done, and there were also an attempt to try and enforce some kind of cooperation as envisioned under the Ansi-Tramodo law. Now, question is, do you think it worked? maybe before we get to that, what were we really trying to do? In many ways, we were trying to do something that has the model law insists on us doing. Suspicion, mistrust got in the way. Practitioners and judicial officers managing its whole cross-border insolvencies must understand that there is need for a coordinated approach to this thing. Unfortunately, the clients didn't want to hear. They didn't want to know. Now, in trying to enter into this consent judgment, what were we trying to do? We were trying to do what others have done before. There's something called a protocol. A protocol, heard of a protocol? Protocol is where in situations like this, office holders of different entities in cross-border situations kind of agree on what everyone will do. The first of such a protocol was done in a case called Maxwell Communications Company, the bankruptcy of Maxwell Communications Company Limited. Maxwell company was owned by a man called Robert Maxwell. If you remember, any of you remember Macmillan Publishers? You know the Mirror of London? It was owned by a man called Robert Maxwell in this company, Maxwell Communications Company. That Robert Maxwell is the father of a famous person called Ghislaine Maxwell. Familiar? Familiar? Oh dear, you have to follow the news. She's a very important person. So, because when Robert Maxwell died, it was found that a lot of his wealth was actually hot air. It was built on fraud. Fraud across the US and the UK. That is what had buttressed his money. And in fact, his death is considered is highly suspicious because he kind of had touched pension money, pension of his own workers. So now, because of the intricacies, fraud and all that, and the bankruptcies that followed, it became necessary for the office holders in the UK and in the US to kind of come down with a framework that they presented before their respective courts. And the courts sided and said that will work. A framework that allowed them to cooperate and coordinate the administration of those processes. That was the first of those cases. Now, as you celebrate that, in the Notel case, anyone familiar with the Notel? Notel, the big teleco company, went down in the US and Canada. As intricately involved as those two cases were because of the cross investments, especially by pension funds, it became necessary that the courts of the US and Canada had a joint hearing. Each to just kind of hear what the other arguments are and just kind of restrict itself to the facts and the law of its respective countries. So the cross-border arrangements do not necessarily mean that you take away sovereignty. You just want to avoid a confusion of the two countries. You use your own law. If you don't have a relief that is applicable to your law but is applicable out there, you leave it. Use your law. That's how this works. So these advancements have gone that far. You can imagine joint hearings to just be able to understand and avoid two conflicting judgments from two different courts of two sovereign countries. So these advancements, as you can see, are triggered by practitioner pragmatism and creativity. So you, ladies and gentlemen, are the ones who are going to drive this. You're the ones going to drive this. In the case of Spencon, we certainly had our problem. We didn't achieve what we had wanted. We achieved what we wanted, to keep them away. Don't come to us. But in all this, the truth of the matter is that the directors got away. They took away with the loot. If we had agreed on how to take a joint approach on a criminal matter, because the thieves are known, maybe we could have got more value for the creditors. So what are the lessons to take from this? The need for a commitment. We lacked the commitment and the creativity of practitioners to ensure full cooperation. We stayed in our territorial silos. You know, the two banks in Uganda each decided to have a receiver. So I was a co-receiver with somebody. They insisted on having their receiver because of that level of mistrust. Tanzania did not even benefit from this at all because there was no appointment there, was left out despite its borrowing from Uganda. And then, so you had PwC in Kenya trying to get into Uganda. The Ugandans are here, the Tanzanians over there. So you can imagine the cost of recovery that was involved in there. The confusion of the consent should have allowed for some court-to-court communication to see how we are all doing on this very big and important case. Some supervision on how the office holders were doing. But in reality, it was also a hard paper for the judges. So by the time you're suggesting a cross-border communication, it's already too much to process. These things were new. We had over 1,000 applications in court. The first of them, to set aside all the transactions, the suspicious transactions. And that alone was a challenge for the registry. How many are 1,000 applications? How many do you handle a year? So if you go to the records in Uganda, Kampala, there is a year when Kavito Karamagi was the biggest court user because of one case. You know? And the judge has to write 1,000 rulings. So there were things to think about. We have to be more practical than this. And now, why is it important for us to do this? It's because of the opportunities we have. Look at the African free trade opportunity that we have. Listen, how big are your yams here? I'm serious, how big? How big are your pineapples? Big. You can't take them to Europe because the families there are small. They want 1 kilo. But if you sell it to Uganda, we don't care. We eat it. Yeah. Family of 15, we eat your cassava, we eat. So the trade opportunities are with us. We can fight all the genetically modified nonsense and so on. We will also get better returns for our creditors if we cooperate. We need to start building jurisprudence. Because this is going to be normal. Gentlemen, my name is now Tinubu. I am going to come here more regularly because you call me. What does that mean? There are others that are going to come. So we need to start building some of these things, these skills, and start a discussion that leads to this. Then the other thing, what fails bankruptcies all over, is an issue of financing. Now, if you're chaotic, then it means you lose the chance for a coordinated approach. I want to speak a little bit more about the benefits of this model. It offers procedural, I want to be very clear, not substance. It just allows for the whole office holder of a foreign entity to just embed himself and access the remedies that your law allows. That is all. It allows and facilitates some kind of order. You can't be selling here, then another one is doing this and that. No one is accounting to the other. This was one entity after all. Okay? And the law allows for adequate protection of local creditors. Just let us know what you are doing. People, we are one people. I am Tinubu now because we are one people. You know? It makes more, it brings more certainty to a cross-border case because you all know what you are doing and it simplifies the process. All these are benefits. We'll make more money. I want to thank you. Did I do the 20 minutes? Fantastic. Thank you very much.
Thank you very much indeed. I wouldn't describe Miss Maxwell as famous. I think I'll say infamous. Right, now we're going to Zambia. I hope Milord is online. He is? Excellent. So we have Judge Chende Kazimbe, who will speak to us on judicial case management, exploring strategies for speedy and efficient resolution of insolvency matters from a Zambian perspective. Please welcome, my lord. Thank you.
Thank you very much, Madam Chair, Mrs. Boma Alabi Owansan. Good morning to you. Good morning to my fellow distinguished panelists. And indeed, good morning to our ladies and gentlemen in the audience, physically and virtually. I'd like to thank BRIPAN for this invitation to appear at such an important conference. It is indeed a great pleasure and privilege for me. I would have loved to be there in person, but due to circumstances beyond my control, I can only appear virtually thanks to technology. Now, mine is to just discuss with you on this very important topic of case management in terms of sharing some perspectives from Zambia. I will begin by sharing the screen, pardon the pun. I hope the screen is visible. So my discussion is split up into 5 parts. I'll speak a little bit about the philosophy that underpins case management. I'll move on to the what and why of case management. Thereafter to the tool set, skill set, and mindset for it, as well as delving into some examples before concluding. The philosophy of judicial accountability underpins case management as I have seen it in Ghana. So we can say that judicial accountability is quite useful for effective case management. And our Chief Justice actually reminds us that judicial independence goes hand in glove with accountability and transparency. We are often told that as judges we are accountable for both the quality of our decisions and indeed the turnaround time. Our Deputy Chief Justice actually tells us that there is no black and white because justice is either managed or mismanaged. And for all of us who are involved in insolvency can appreciate that delay destroys value. Now in Zambia, the approach taken to litigation is that we have done away with judges being considered to be a neutral arbiter in a battlefield where this adversarial gladiators actually counts to the bitter end. Litigation is now wholly judge-driven. We and the judge are speaking. So the question then gets the answer. What can we describe case management to be? Case management can be described as a system by which we as judges take charge to objectively drive the justice process. And the objective of this is the proper and efficient administration of justice, because that is what our Constitution enjoins us to do. Moving on to why case management can be considered as important. There are various reasons for this. I think we can say that there is no room for autopilot in cases, because remember in Zambia, it's all about judge-driven litigation. And autopilot can actually have very nasty consequences, because it displaces us from the driver's seat into a reactive role that is dictated by the various role players, who can include our support staff, the lawyers, and the litigants. The undesirable consequences of not having effective case management are obvious inefficiency amongst all of these role players, including ourselves, delayed rulings and judgments, reduced disposal rate of our cases, and accumulation of that much dreaded fact. Such would obviously impact on the quality of our decisions, because we then move from doing the best that we can to just churning out decisions like it's a conveyor belt. Invariably, in the absence of effective case management, we have heightened stress and burnout from the backlog and other pressures that point negative arrows at us. This also impacts on the credibility of the institution, which loses face to the Zambian public, and ultimately erodes the function of the judiciary, which includes to maintain checks and balances on the executive and legislature. Ultimately, over time, this would impact negatively on the rule of law. So now we move to a two-step for case management. I am quick to point out that we do not have a specialized insolvency court in Zambia, and we do not have specialized court proceedings for insolvency cases. However, our Chief Justice has made strategic interventions in general civil proceedings, both in terms of the rules, administrative guidelines, and case management guides, which serve as tools to actually improve our case management. And some of these tools embedded in this combination or catalog that I've spoken about include prescribed time limits for disposal of cases, meaning that every case that is begun has a time limit within which it must end. So if an insolvency case is brought by petition, winding up petition, we have 1 year from the date that it began to dispose of it, failing which it goes into administrative backlog with consequences. If an insolvency matter is brought by way of originating summons or originating notice of motion, we have 45 days to dispose of it. Other tools for case management include enhanced powers, which we can exercise at case management conference teams. I had spoken about how there's this shift to judge-driven litigation. So because of that, changes that were introduced to our High Court rules actually give us sweeping powers case management conference stage. We can pry into the pleadings, and if they are not clear, we can force them to be changed so that the parameters of the case are clear and not obscure. We can delve into preliminary issues so that we get them out of the way and there are no imaginary roadblocks to quick in, quick out. Another tool that is embedded in our rules is the option of alternative dispute resolution. So our rules allow us to actually market the benefits of alternative dispute resolution, part of case management. We also have a tool introduced, which is a cut-off period for interlocutory application. And this practically means that no interlocutory applications are allowed to come in less than 14 days before the date fixed for a trial or substantive hearing, unless there are very limited exceptional circumstances. There is also a general prohibition of adjournment unless there are compelling exceptional circumstances. A notable tool that we have in our rules, aid case management, is also time limit for delivery of our decision. We now have a mandatory 90 days from date of last submission in an interlocutory application to deliver our interlocutory ruling. And we have a maximum of 180 days to deliver our judgment from date of last submission after substantive hearing. In terms of the skill set for case management, and this is important because in order to make use of a tool set, we need to be equipped with a skill set. So as Zambian judges, we've greatly benefited from various capacity building initiatives that equip us with a skill set to proficiently deal with insolvency cases. And the initiatives include having case management as a recurring topic for discussion and training at various conferences, roundtable meetings, internally for our judiciary, with a view to just harvesting some form of local best practice in terms of what is working in the different portals of our judiciary. We've also benefited from on-site training from cooperation or development partners on international best practice. And some of these development partners include the World Bank, the International, who have been to Zambia to train our judges both at first instance and appellate level on insolvency litigation. We also benefit in terms of this skill set from being supported to attend international events of relevance. Again, notable amongst these are the Insol International event and also the events of the Standing International Forum of Commercial Courts. Our judiciary also supports us to engage in specialized legal education in the realm of insolvency and any other topical area that requires specialized capacity building. Our judiciary also supports us to become members of international associations that are concerned with insolvency, such as Insol, and this obviously gives us access to a wide array of materials which are the privilege of members of such organizations. Moving on to the mindset of case management. So you can have an enabling tool set, you can be equipped with a skill set, but you need a mindset to actually activate the benefits of the tool set and the skill set. So this little table shows us where our energy should go in Zambia. So we like to promote anything that gives us control and monitoring power over the case, and preserve anything that works against it. We support anything that makes us proactive, because remember that litigation is just given. Anything that speeds up the case finds favor with us. Judicial time is a limited resource, so we support anything that saves time. And I must say that in practically applying this mindset, it is useful to do a self-audit and list the people, factors, practices, and processes that must be fed as results to staff, so that we maintain a firm grip at each stage of the case. Now moving on to some examples of case management in insolvency cases. One of the ways in which we often deploy is to force our counsel, talk out the parties and stakeholders, and then set the ground rules. Typically, this happens at case management conference days where we tease out their true intentions. And for those that we detect as having mindset of hindering progress or trying to abuse the process of the court to achieve an ulterior motive, we know how to compensate, and we actually set the ground rules and tell them that we need them to cooperate with each other and to cooperate with the bar to foster a problem-solving environment, not a problem-compounding environment. We also warn them that any tactics that we see that coordinates this culture shall be dealt with then by us, including punishment where need be imposed to be borne by the law. Another example of use of case management, and I did touch on this earlier, is in the deployment of alternative forms of dispute resolution. Our very first speaker, Her Ladyship, did speak about the use of ADR in insolvency cases, and indeed this is something that we do, where as a gatekeeper, we interrogate the parties and see whether, for argument's sake, winding up is the only way in which their grievance can be dealt with. And if instead they cannot explore mediation, and we highlight the benefits of why mediation should be considered. I had an example also where we used arbitration because it was one of those winding up petitions brought on account of inability.
Recording in progress.
One of those winding up petitions brought on account of inability to pay, and after engaging the parties, we found that there was an arbitration clause in the contract. So I encourage them to instead pursue arbitration, which would be a less destructive form of resolving the problem. And they bought into it, and the case ended in that manner. We also use case management, again as gatekeepers, to see if there is a way in which another insolvency proceeding is more suited for the circumstances than the one that has been brought. Take, for instance, again, winding up because it's a really drastic and disruptive form of insolvency proceedings. We use case management to sow the seed as to whether perhaps business stress should be considered as a more progressive form and suitable form of insolvency proceedings. We also use case management to evaluate the evidence that is in hand in terms of the inventory of it, and to see whether what we have is adequate to actually properly hear and determine a case, and if not, we issue directions to bring in supplementary evidence. Another common example of use of case management is to overcome preliminary issues and disruptive interlocutor application. Remember, judicial time is a limited resource and delay destroys value. So we need quick in, quick out. So just by having genuine dialogue, case management conference, or any other convened meeting, we are able to actually drill down to the real issues. And it turns out often that what appear to be big preliminary issues are actually non-issues or perhaps ego issues, which we can then get out of the way and drill down the substance matter. In summary, a perspective to consider from Zambia on the subject is that a useful philosophy to anchor effective case management is that of judicial accountability. Successful case management can be aided by having an enabling process, whether it's through legislative provisions, rules of court, administrative circulars, guest guides, or otherwise. Also having an equity mindset that capacitates us to make good use of the process. And lastly, to have or inculcate a mindset that actually activates the true set and skill set to achieve effective case management in insolvency and other proceedings. Effective case management can greatly improve the quality of our decisions and turnaround time in insolvency cases. With those few words, I wrap up my presentation and thank you most sincerely for listening.
Thank you, my lord. I think we can say thank you much. Wow. That was amazing. Justice is either managed or mismanaged. Delay destroys value. Litigation is judge-driven. I took that away. And what's resonating here across borders is training. Training for the judicial officers, and then empowering. Well, I don't even know that we can empower the judicial officers. You're my lords. You've got the power. It's a question of using it, and making sure that these things progress as they should. So now the floor is open for questions and comments. We do not want a lecture or a paper from anyone, please. If you have a question, please identify yourself, keep it brief, and by all means address it to one of the panelists or generally if you wish. Do we have ushers who can take a microphone around? Okay, I can see a hand up there. I see you. Anyone else? Because I'd like us to take perhaps 2 or 3 questions before we go round to the... I see you. Thank you. Anyone else with a question or a comment?
Thank you. Good morning. My name is Tony Krukrubo. I practice in Port Harcourt, the southern part of, deep southern part of Nigeria. And my question and quick comment is directed at Milord from Uganda. Milord, very insightful presentation. And I like the fact that you detailed into the impact of the African Continental Free Trade Area. So my question is this. My Lord, you are aware that we all operate different across the continents, Anglophone, Francophone, civil and common law. And I would venture to say that one way to work towards some kind of insolvency harmonization would be what most African countries are already doing, including Nigeria, an adoption of the UNCITRAL model. But I was keen on hearing a bit more from you because you touched on it. I would say you didn't go too deep. If you could just flesh it out, how do I, as a legal practitioner in Nigeria, relying on the 2063 goals of the AFCFTA, wake up one morning and say to my clients, I have an order here in Nigeria. I'll come to Milord's court in Kampala, Uganda, and get it enforced without having too much hindrance because I'm possibly going under the protocols of the African Continental Free Trade Area. What are the difficulties you see, and how soon do we get to that point? That's my question. And just to say, Your Lordship, that not only do we have big yams and pineapple, our plantain is also something you should look forward to. Thank you.
Thank you very much. We have a question from over there, that gentleman.
Okay, thank you very much. My name is Prosper Mbaka. I came in from Abuja for this conference. Yeah, my question is directed towards Mr. Kabito, and it's also in respect to the SPENCOM case. It's quite interesting, most especially with respect to the cross-border elements of the case. Then some weeks back, I was studying on transaction avoidance And we see that the appointees of ECP, within the period they were in charge of the company, they had done some transactions that possibly they shouldn't have. So my question borders on when you are appointed or when an insolvency practitioner is appointed, could there have been a situation where you could review some of those transactions, the asset strippings that were done, and void some of those transactions and maybe recover some assets from the actions that were taken by the appointees of ECP? Thank you.
Thank you very much. Any other question before I... Okay, please go ahead. He can go ahead, yes.
I am Ayanla Jadam Oyola from the University of Lagos, Faculty of Law. So my question is directed to the learned sage that talked about, I think from Uganda, sir. So Baba said, knowing well, I said, the question goes to us, knowing well only 22 countries had adopted the UN Central Model Law on Insolvency. So what can be done to spread the knowledge of, to spread that UN Central Model across the African nations, as that will really ease the problem of interstate, when I talk about interstate here, I mean inter-countries or within trade within Africa. So what can be done, as we have to make sure at least more than 50 countries adopt this UN Central method. Thank you, sir.
Thank you, and we have a hand up there, the lady.
Okay, thank you very much. So from the case study that we had, the Spencon, I realized that the company has staffs. Some of them had their suspicion. They could see that mismanagement was going on. Some of them didn't even want to speak out. So I want to know, is there a mechanism that can be put in place within the insolvency practitioners that allow companies, especially the staff of the companies, when they notice that, because we are here to rescue companies and not to kill it, when the staff of the companies notice that the company is being run down, they can approach like BRIPAN, for example, in Nigeria, and say, we are suspecting that this our company will soon die. Can you do something for us? Is there something like that?
Your name?
Nkechi from Abuja.
All right. Thank you very much. That's 4 questions. And I think we'll start with Milord in Zambia and then come to the panelists who are physically present.
Thank you. Could the question please be repeated? I think
Uganda.
It must have come at the point that...
You're the culprit. All right.
I feel targeted.
Hello? I was saying that could the question please be repeated? Because I think it came at the point that the BRIPAN microphone was on mute. I didn't get it.
Sorry, Milord, that question was not actually directed at you. It was directed at a speaker from Uganda. So I'm going to give him the opportunity to respond to that now, except he wanted to make a comment on the questions that have been asked by our delegates.
Yeah, I thank you for the questions. I just need to remind you that there are about 4 other panelists. So, and they all made very wonderful presentations. The first question, I see all the questions for me, so I thought I should say that. The gentleman who asked about benefit of the Africa Continental free trade area, and what are the challenges? How do we surmount them? Yes, it's true. It's true. We have a lot of challenges. We are a continent of 53 countries, 55 countries. And all these countries are not our creations. They, you know, when I hear some of my countrymen say, I'm Uganda, I'll die for Uganda, it's a creation of the colonialists. The boundaries are not ours. But there's an opportunity to build a one continent. And that work is in progress. I keep telling, I use an example back home. Before, I could not travel to Nairobi, Kenya without a passport. I had to get a passport. Eventually, I could travel, I could get a document at the border or something. Eventually, they introduced an East African passport. So I had to have an international passport and an East African passport. East African passport for travel within East Africa. And then the other to travel out of East Africa. But today, the East African passport is an international passport. I traveled here on an East African passport. And I can travel in East Africa with my national ID. So these things are getting, I'm sure the ECOWAS region is similar. We're working towards harmonization of and mutual recognition in East Africa for us to be allowed to work across border. I think these initiatives are the ones that are going to drive this. And importantly, that it's you, like I said, you're the practitioners that are going to do this. Yes, the divisions, Anglophone, Francophone, and the perception that we are very far apart, that Nigeria is very far from Uganda, far from their reality. It's becoming for me, in my mind, it's becoming closer and closer. And as we build our own practices, I think the challenge before is that our practices had not developed to a point where we need to have this discussion. Insolvency itself is a new subject, and so we have not yet developed a culture of rescue. I'm sure the case for Nigeria, as is the case in Uganda, although it's closely changing, is that insolvency as a subject is probably taught as an optional, and it is probably taught from the experience of how to liquidate, how to start a bankruptcy proceeding, and so on. So for us in Uganda, we've been able to realize that there's a need to start the culture by arming the professionals that would advise the clients. When a client comes to you and says, I have this problem, the bank wants to do this to me, or I have this creditor, giving me this problem. The problem is to look at it from just that very narrow perspective, rather than from the very holistic view of where the challenge, of where the client's problems are. So once we do that, then we will upgrade our discussion to cross-border. The first people to notice the company is likely to be in trouble are the auditors and the accountants. But what's the chance that they can tell management, we need to apply for rescue, or we need to start rescue mechanisms or turnaround strategies? I don't get a sense that that happens a lot in Africa. Auditors are quickly just to get their money and get out. Accountants, they start seeing things are bad, they look for a new job. So if we start having a discussion within ourselves as professionals, to arm ourselves to advise our clients and head them towards rescue, I think we will then upgrade our discussion to then cross-border more. But even if it's a cross-border issue right now, the courts in Uganda are ready to help you. As you can see, the problem with the law, that one was dealt with. Uganda, I think, was one of the first countries to adopt the model law, and also put a new insolvency law. So we're ready, and others are coming. I've been in a situation where I have seen now 22, where there was none before. And this has happened in the last 10 years. So there's movement towards it. Let's continue the discussion going, but let's open ourselves to the possibilities. Even if it's not possible, the question is, it's us to be pragmatic and be creative. So I throw that back at you, so I don't know whether I've been able to navigate it fairly for you. The second question was about reversing the transactions, the voidable transactions. That's what I did with the many court applications that I talked about. And it was a whole new process. For the courts, how do you even open a registry for that? Which judge? And we had to make a case and say, these cases have to go before one judge. I had to have meetings with the head of the division to explain how this works. That's why I'm saying that for us, we're really starting from the basics. And it's kind of, you resigned ourselves to the fact that we are the guinea fowl, the guinea pigs. We are the ones setting the precedent and charting the way forward for many to follow. So in having a discussion with the court leadership on how to do this, to how to even serve. How do you look for 1,000 people? Where are they? I've just got names. I don't even know whether they exist. So we had to have a discussion with the court and said, okay, run 3 adverts in the newspaper. That will suffice. Thank you. You imagine 1,000 cases? Really? And the other discussions to have, must they all be filed? Must they all be had? Can I have one test case and then others follow? Would it work? So those were some of the challenges. But down the road, I can tell you that we were not entirely successful in that recovery, because when it came down to enforcement, then the registrar said, wait a minute, you first tax your bills. I cannot give you an order. I said, okay, I've waived it. Around that time, they created an execution division, so the files have to. Now, if someone has sold a car, has bought a car at 10% the value, is that car still likely to be on the road when he gets to know what's happening? So probably the cars were dismantled and sold, and soon it became an effort in futility. But at the very least, we took the lessons. We know that doesn't work. The court processes need to work, need to change for this process to work. So it's work in progress. For me, my view is that it's work in progress. I hope that, good sir, answers your question. Thank you for your comment, the Don from University of Lagos. I think we all agree that we need more people to sign on, because we are going to be affected. If trade across the country, across the continent is increasing, so are the risks of bankruptcies and insolvencies, and the need for us to have a coordinated approach towards them. As professionals in this room, we should be able to make that argument, because we've seen what happens when there's chaos. We've seen it. No one really wins. Okay? As regards the mechanisms for staff to report mismanagement, incidentally, that has come up. I have, in my work, had people come to give me information. And really, they come to give this information because they are worried for their jobs. If this company goes down, I'll lose my livelihood. This is what is happening. I see this problem happening, this company going bust in another, 3-4 months or something. But that is a discussion now for the team to come to professionals like you, and then maybe you work with creditors so that they can, start the necessary enforcement processes. Because at that point, management has really gone away. It's on leave. If they are not taking any action, we will have to induce a crisis. So those are, for me, the instances I have seen. I don't know that you can create a legal process as such, but I see some kind of whistleblower tendencies. These ones come and they come have a word with somebody. And this information starts coming out in the bars, in the churches, when they start praying for the management, and that's when these things come up. So it's for you as a professional, I think you have to have your ears on the ground. And if you have a client who is invested in this, then you can have the discussion about how to save it. Those are the 4 questions I had. I hope the 4 questions are for the others. Next 4 questions.
Thank you very much. We'll take a final round of questions and then closing remarks from our panelists. Do we have any more questions? We have a hand up there. Can you please take a microphone over to the lady? Over there. Anyone else? Going? Going? Gone.
My name is Bola Tumi Animashao, the second Vice President, NBA. Mine is just a comment and an appeal for our facilitators. I want to say a big thank you. And we are looking forward to have a collaboration between BRIPAN and the judiciary. It will be very lovely. And our conference will not be in vain. So my appeal is to the Council of BRIPAN that we should not just allow this to be a talk show. And I think they have noted a lot of things, recommendations that are being made. We are looking forward to see an improvement so that by the time we have a next conference, it will be a recap or testimonies of what we have been blessed with today. Thank you.
Thank you very much. I think I align myself with that appeal because processes. It just makes everything so much speedier. Good, we'll hear from the President.
Thank you very much, Chair. Just in quick response to the NBA Vice President, I just want to say that we have always had a good collaboration with the judiciary, both at the Supreme Court, at the Court of Appeal, and the Federal High Court. In fact, presently, BRIPAN is also working out some judicial summit with the judges of the Federal High Court. And as soon as we have or we get the signal from the National Judicial Institute, I'm sure that that will be actualized within the next 1 or 2 months. Thank you very much.
Thank you very much. Now, I'm going to give the panelists an opportunity to give us some closing remarks, starting with my Lord of the Court of Appeal.
Thank you very much. Obviously, the comments reveal that most of our audience today are insolvency practitioners. My fellow panelists from Uganda had to do quite a lot of responses, which I'm sure you're all satisfied with. I just want to emphasize the point I made earlier that insolvency practitioners, you should look into really using ADR for pre-insolvency resolutions. When you have the negotiations and all, that can be resolved before you now involve the courts. I was going to make a comment that the President seems to have picked up on, that BRIPAN should continue to work with NJI to ensure that there's a lot more of capacity building because of the nature, the specialized nature of insolvency proceedings. There has to be continuous capacity building. Thank you very much.
Thank you, my Lord.
Thank you, Mr. Chairman. Finally, let me emphasize that the role played by corporate entities in the national economy is immense. As artificial citizens of the Federal Republic, they are entitled to be rescued Just as natural citizens are entitled to medical attention when they suffer, corporate rescue is of essence, so we can have businesses that experience a bounce back with competitive edge. The role of the Nigerian judiciary in the conduct of proceedings is to create a balance when considering the competing rights of stakeholders and tilt towards rescuing companies rather than allowing them ease out of the corporate stage. Thank you.
Thank you very much, Milord.
Thank you. Of all the conferences I've addressed, BRIPAN conferences, this one has really been engaging. But I think I need to emphasize that the opportunity that we have, and especially for you Nigerians, you are the African powerhouse. You stand to benefit from this. So for Nigerian insolvency practitioners, please take the lead. You are the chief spokesman for Africa. You are, for the rest of Africa, when we are grumbling and unhappy about something, you're the ones that speak up. You're the ones that move things. So you have a very special position here as Africans. The other that I want to emphasize is that insolvency is a practice of creativity and innovation. We don't have all the answers. We're always in uncharted waters. And so this problem of cross-border insolvencies, as it emerges in our own complexities, you Nigerians, because of who you are likely to be the people that we're watching. So don't abdicate your role. It's my challenge to you, BRIPAN. Thank you.
Thank you very much. And if we can have closing remarks from my lord in Zambia.
Thank you very much. Just to emphasize that as judges, we are accountable to you. And in being accountable to you, we consider insolvency litigation and indeed all civil litigation to be a problem-solving exercise. In that problem-solving exercise, case management is crucial. In insolvency cases, the stakeholders in that case management exercise include obviously us as judges playing the lead role, but the bar, insolvency practitioners, litigants, and indeed all stakeholders in the insolvency cases are role players. So I invite you to play your part to support the problem-solving exercise through case management. And in so doing, you will allow us and help us to be accountable to you in terms of the quality of our decisions and indeed the turnaround time that we need and serve in insolvency cases. I thank you.
With that, we've come to the close of this judicial roundtable. I'm sure you'll all agree with me that our panelists did justice to, I think I've got too many microphones, to the topics, beginning with Honorable Justice Onyeka Otisi on the role of the judiciary in deepening insolvency tools for resolving commercial and financial challenges. My Lord Honorable Justice Otisi, JCA, I thank you for the industry that went into this presentation and for giving us such an erudite presentation as well. Also, on the topic of reappraising the role of Nigerian courts in promoting corporate rescue, my Lord Honorable Justice Alexander Owoye, thank you very much indeed for your presentation. And Mr. Kabito Karamagi, strategies on engendering judicial cooperation and assistance dealing with cross-border insolvency. I thought we all found that very, very interesting. And finally, last but not the least, Honorable Justice Chenda Kazimbe of the High Court of Zambia. My Lord, I thank you very much indeed for your presentation. I know that he would have wanted to be here in person, but the opportunity did not present itself. So, and finally, I also thank BRIPAN for the opportunity to chair this session, and now invite coordinators to tell us what next is going to happen before we leave the stage. Thank you.
Thank you very much, Leonard Sick, and to all the panelists, thank you very much. We'll proceed with the presentation of a little talking to our speakers in appreciation for your time and for being with us today. May I kindly call on Mr. Sheyi Akinwumi, past president of BRIPAN, to do us this honor. Okay, so may we also invite our distinguished guests to join us in the group photograph. Our chairman of the Conference Planning Committee, president of BRIPAN. Okay.
Distinguished ladies and gentlemen, joining on the stage, we have Mazi Afamosigwe, SAN, President, Nigerian Bar Association. Please put your hands together for him. We would also like to recognize the presence of Malam Haruna Yahya, MNI, PhD, FCA, President, Institute of Chartered Accountants of Nigeria, ICANN. Please put your hands together for them. May we have music in the background as we take the photograph? May I request for the second pose that you have smiles on your faces? Thank you. Aha. And of course, on stage we have Mr. Akintunde, who is our past president, immediate past president. Ladies and gentlemen, we'll move now straight into the presentation of the gifts. Just to say a big thank you to our panelists for the job that they have done. It is in no way an easy task, but they have done it excellently well.
Thank you on behalf of BRIPAN, Council and members. We want to say a big thank you to Umar Alabi, ON, SAN, and my sister. Thank you very much for this. Beloved Justice Utisi, we thank you very much for taking time to be here, but also for the wealth of knowledge that you have shared with us today. We're very grateful. God bless you.
Please put your hands together for her. Thank you, Ma'am. Coordinators, may we have a bit of assistance from the BRIPAN team, please, as we see that our ushers seem to be busy. Let's get this from them. Thank you.
Thank you, Kabito Karamagi. Kabito is one of the, we started this journey in Africa quite a while ago, and some of us are still here. He's one of them, where we started the round table and all of that many, many, many years ago. So thank you very much for continuing this journey and for all the answers that they bombarded on you, that you answered, bombarded on you.
Please, may we put our hands together for our brother, Mr. Tinubu. Mr. Bola Tinubu, our dear brother.
Thank you, my Lord. Justice Owoye, not Owi, but we're very grateful for being with us today and taking time from your very busy schedule to share this with us. Thank you very much, and God bless you.
Thank you very much, sir.
We also thank Judge Chenda Kazimbe. I met him last year in Botswana. Fantastic person, really very knowledgeable. We'll ask somebody that we don't know to help us come and take it on his behalf. Okoria, our future president of BRIPAN, should please come and take it on his behalf.
Thank you. A big thank you to the coordinators for this session. You have done well indeed. All right, distinguished ladies and gentlemen, please may we settle down now. I see that we're excited and there are a lot of conversations, cropping up from our first session for the day. This is good to see, but please may we sit down. We need to continue now. All right, please, may we settle down. Photographers, we will have time for photo sessions. Thank you. Distinguished ladies and gentlemen, please be seated. Please be seated. Please be seated. Please be seated. Ladies and gentlemen, me lords, may we please be seated. Thank you. Thank you. Thank you. Thank you. Thank you. Daddies and mommies, please be seated. Daddy, please be seated. Mommy, please be seated. I see that a lot of you are responding to daddy and mommy first. When I said distinguished ladies and gentlemen, you didn't answer me. My president, we may meet in court too. Thank you, sir. We may meet in court. Thank you. Distinguished ladies and gentlemen, I'm about to call up a man who has achieved so much and who in so many ways represents not just his industry but Nigeria on the global map. He's going to come and give us his goodwill message. I'm about to call on no other person than the president of the Institute of Chartered Accountants of Nigeria. But permit me to read out his profile, a brief one. Dr. Haruna Yaya, MNI, PhD, FCA, is the 61st president and chairman of the Council of Chartered Accountants of Nigeria. He holds a BSc in accounting from Bayero University, Kano, and an MBA from Ahmadu Bello University, Zaria. He also holds a PhD in accounting from Ibrahim Badamasi Babangida University, Labia, a fellow of ICANN, CITN, and several other professional bodies. Dr. Yaya is the founder of Haruna Yaya & Co., an auditing firm affiliated with MGI Worldwide. His firm provides top-tier services to both local and international clients, including the World Bank, AFDB, and the EU. Dr. Yaya also serves as a board member of the Association of Accountancy Bodies in West Africa. Also, he is on the board of the Pan-African Federation of Accountants, PAFA. He has been a member of the ICANN Governing Council since 2011 and is actively engaged in various community services. Dr. Yaya is married with children and grandchildren. Ladies and gentlemen, a man who is contributing immensely to our society, to the world around him. Please put your hands together, make welcome Malam Dr. Haruna Yaya.
Thank you very much. The President of BRIPAN, other council members present, my distinguished delegates, because without you, there is no conference. I stand on all existing protocol. Good afternoon. It is with great pleasure and honor that I stand before you here today to bring to you warm greetings from Institute of Chartered Accountants of Nigeria. Our role of business recovery and insolvency practitioner is vital in ensuring the stability of our economy, particularly in these challenging times. Our work helps to restore business and safeguard livelihoods and ensure that companies can keep to changing economic conditions. As we gather here today, I'm reminded that of our responsibility we all bear as professionals to contribute to the development of recoveries and resilience in a thriving economy. Every conference is supposed to end with a communique whereby we will come up with workable recommendations that will enhance the professionalism of business recoveries and insolvency. Without prejudice to what my learned friends have said yesterday, and without prejudice to what the community may come up with, from ICANN perspectives, we wish to recommend the following solutions that will enhance business recoveries and insolvency in Nigeria. One, we should improve on legal and regulatory framework by modernizing insolvency laws. That is, we need to update our CAMA 2020 to align with global trends in corporate restructuring and insolvency practices. We also need to implement cross-border insolvency practices by adopting international best practices for cross-border insolvency to facilitate smoother business and recoveries integration into global marketplace. Furthermore, we need to encourage business recovery mechanisms by imbibing company voluntary arrangements where companies will restructure their debts and avoid liquidation, because our objective is not to kill the company, but is to restructure it. There should also be company administrative mechanism to ensure that they provide temporary moratorium period for assessing best paths forward for distressed companies. Furthermore, we need to have a strong institutional support by strengthening BRIPAN's role and empowering Business Recovery and Insolvency Practitioners Association of Nigeria, BRIPAN, to regulate practitioners, provide training, and promote best practices. We need also to have judicial development to enhance judicial capacity to handle insolvency cases effectively and efficiently. So may I suggest that BRIPAN should move from association and get more capacity to ensure that we have teeth to bite. Also, we need to have capacity building, continuous training, and public awareness. We also need to encourage alternative dispute resolution, mediation and negotiation, utilize alternative dispute resolution method, such as mediation and negotiation, to resolve insolvency cases outside traditional court settings. Furthermore, and in the conclusion, we need to have judicial roundtable, where we establish a forum for judges to discuss challenges and share experiences in handling debt recovery and insolvency cases. As ICANN, We remain committed in supporting your efforts and fostering collaboration between our two organizations. I'm confident that the continued synergy between the two bodies will lead to a remarkable strides in promoting financial recovery and resilience in Nigeria. May your deliberation today be fruitful, and may your contribution continue to shape brighter future for our beloved country. Thank you, and God bless. Oh, I should continue as MC.
All right, distinguished ladies and gentlemen, from one president to another president. Please may we put our hands together for Mr. President, NBA.
I was represented at this event yesterday by my mommy, as I call her, Mrs. Bola Tumi Anima Shaun, the second vice president of NBA. And so she has given my goodwill message on my behalf yesterday. So I'm just tempted to say thank you so very much for inviting me up to the stage for a second time. But then, it would be nice to say that the theme for this conference is very important. There is constantly a misunderstanding that when a receiver is appointed, his or her job is to take steps towards a burial of the business, and that need not be so. And I think this conversation would help us to understand that the idea of some of these appointments is to restructure a business that is struggling to meet its financial obligations so as to pay off creditors and ensure that the workers are paid and the business remains a going concern. And then also to avoid some of the intractable litigations that oftentimes ensue in the process of receivership. And so there is need to deepen our understanding of our role and our involvement in such activities, to let us understand that our presence or involvement in such activities is not to make it difficult to restructure the businesses and pay off their indebtedness, but also to find a win-win situation that makes it possible for the creditors and the debtor to coexist and continue to live together without leading to the death of the other. And so I'm glad that BRIPAN has not only convoked this conference, but has also invited people like us to learn more, because knowledge never ends. We never know enough. And for every day we listen to others and share ideas, we learn more and we are better for it. And I pray that BRIPAN will continue to do or provide the much needed services that utilizes cross-sectoral, cross-fertilization of ideas to ensure that businesses that are struggling are helped to pay off their obligations and continue to exist. So thank you so very much as we continue to economic development of Nigeria and ensure that businesses are able to survive the troubled times and troubled financial challenges they may find themselves in due to circumstances that sometimes may be beyond their control. Thank you so very much, sir.
Thank you so much, sir. Ladies and gentlemen, you can do better than that. Please put your hands together. This is indeed a room full of powerhouses. All right. So I understand that a lot of us are clamoring that we just move straight into the next session. The coordinators and the organizers have listened to your request, and we will do that. But they have asked me to tell you that you have just about 5-10 minutes bathroom break. Just 5 minutes. Can we have a countdown on the screen? So the time now is 12:23. You're expected back at exactly 12:43. Thank you. Bathroom break. Please don't go back to your offices. So the bathroom is on the first floor. We have one on the first floor and I think on the ground floor as well. If you haven't gotten your breakfast, tea, or coffee, you can also get that now. It will be a good time as well to network and just exchange your complimentary cards and probably discuss a little bit further on the topics and conversations we've had earlier. We'd also like to let you know that we have Coptic Hospital providing us free medical services just on the ground floor. I'm sure you saw them when you walked in. They are there for us, actually. So you can go do like your blood pressure check, do like your basic checks. So downstairs, ground floor, Coptic Hospital providing free medical services. Take advantage of that opportunity. All right, we would like to take this time to thank our sponsors and supporters. This conference would not be possible without you. We would like to thank Kristen Peter-Booth. Thank you so much. You're a backbone, and we cannot express our love and gratitude for you. Thank you so much. We would like to thank Punuka. We have Punuka as one of our basic support group members. Thank you so much. We also have Babington Ashai and Co. Thank you so much, Chartered Accountants. You are one of our supporters and we are grateful. We have Ayodele Akintunde and Co. Thank you, thank you, thank you. We have Auditor, Fidelis Auditor and Co. as our supporters. We are grateful. And of course, our heartfelt gratitude goes out to Chris O. Okunowo and Co. Thank you so much. Special thanks to SIAO for all of your support. We are indeed grateful. We want to say a big thank you to Chikwem Chambers. Thank you so much for your support. We want to say a big thank you to AO2 Law. We see you, we appreciate you. Thank you. Our thanks goes to Asama Kadiri Legal. Thank you for all of your support. Special thanks to Adebola Shobanjo and company. Thank you so much. And our heartfelt gratitude, our love goes out to Stern and Bland. Thank you so, so, so much. God bless you. And of course, we still have more of our supporters. We want to say a big thank you to Akinwumi and Busari legal practitioners. Thank you so much. Ayodele Akitunde and co-legal practitioners. Thank you so much. Headwaters, integrity, experience, solutions. We see you. Thank you. Templars, thank you so, so much. Bolanle Alao and Co. Chartered Accountants, we are grateful. Ochie Anthony Onochie, thank you so much for your support. Shewada and Co. Legal Practitioners, thank you so much. Not forgetting Sterling Bank. Thank you, thank you, thank you, thank you, thank you. Distinguished ladies and gentlemen, we'd also like to thank our diamond sponsors. We have Zenith Bank as our diamond sponsor, and of course we have FCMB as our diamond sponsor. Thank you so much, Zenith Bank and FCMB. We love you. Also, our diamond sponsors, we have EcoBank, the Pan-African Bank. Thank you, EcoBank. We see you. Stern and Bland partners, thank you so much. Thank you. AO2 Law, thank you, thank you, thank you. And of course, we move on to our gold sponsors. Babalaki and Co. Legal Practitioners. Babalaki and Co., thank you for always being here every year. And our silver sponsors, Punuka Attorney and Solicitors. Thank you so much. SIAO, you are our silver sponsor. Thank you, thank you, thank you. And for our bronze sponsors, we want to thank GT Co. GT Co. as our bronze sponsor. UBA, also here as our bronze sponsor. Access Bank, thank you. Stanbic IBTC, thank you. And of course, our special thanks goes out to Alex. Alex, thank you for all you do. Ladies and gentlemen, a big thank you to all our sponsors, supporters, and support group members. Thank you so much for all you do. We have just about 13 minutes more. Timekeeper, I said 10 minutes, you gave them 20. Did someone bribe you? All right, can we have a bit of music in the background while we wait? All right, ladies and gentlemen, we're counting down. Please, may we begin to settle in. May I request the presence of the coordinator for the second session? May we have you on standby? Ladies and gentlemen, we have 2 minutes more. Please, may we begin to round up conversations and photo sessions and begin to settle down so that we can maximize the time we have. Please bear in mind that we need to hurry through this session so that we can also prep for the gala night. We will be tearing down and setting up. So please work with me. Thank you. Coordinator for session 2, please, may we have you on standby. Time na money. Hey, a time well. Do better, till money go. Oh, thank you, Mama. Thank you, Mama. Come on. Time na money. Time no. Make we use our time well. Abemo na the enter hall. Do better, money go come. Cynthia Ekeka. Music down, please. Music down. Thank you. 6, 5, 4, 3, 2, 1. Ladies and gentlemen, you are welcome back to session 2 of day 2 of the BRIPAN annual conference. We are ready to swing into action immediately. All right. And to take us into the second session, where we'll be looking at professional ethics and career development, we will welcome the coordinator for this session. She is the principal counsel at NULEX. Her name is Cynthia Ekeka. Please put your hands together for the beautiful Cynthia as she makes her way to the stage.
Good afternoon, distinguished ladies and gentlemen. I am quite pumped to be coordinator of the last session of the BRIPAN International Conference 2025. So it's safe to say that the best was saved for the last, right? Is it safe to say that the best was saved for the last? I mean, as a coordinator, I have the right to hype my speakers. So yeah, you can keep your own opinion to yourself. Thank you so much. So we have, in this session, we'll be talking about professional ethics and career development in restructuring and insolvency. And we have 4 speakers that will be in this session. 2 will be presenting virtually, while 2 will be on stage here with us, together with our chairperson. So I'll be introducing them in a very brief form. So I'll rather refer you to the pages that have their bio, pages 39, 40, and 41. If you have this, please. I think we all have the soft copy. So please, I will refer you to those pages, 39, 40, and 41. That's where you have their full bio. So in no particular order, I'll be calling them up on stage. So the first person you have in this panel is Mr. Olusenye Obapasanya, SAN. Senye is a seasoned litigator, corporate advisor, senior executive and senior advocate of Nigeria who has successfully argued landmark cases before several courts in Nigeria that are today precedents on principles of law, including the foundational case on removal of board directors in Nigeria. He currently acts as receiver manager of Arik Air Limited in receivership, a role which clothed him with exercising board duties in place of the board of directors of the company, which at the time was Nigeria's largest airline. Until 2021, he served in the management capacity as the deputy managing partner of Alaniwu Ajayi LP. Please, let's make welcome Mr. Olusenye Opasayan, SAN, to the stage, please. A round of applause for him, please. So as he comes up stage, I will go further to introduce Joe Mitchell Murray, FCA. So Joe is not here, but she is here with us, but virtually. She is the Africa Restructuring, Turnaround, and Performance Improvement Leader at Deloitte Africa, co-chair Africa Roundtable. Joe brings significant lender-side perspective to the service offering, having led teams in a leading local South African bank, as well as a global alternative credit finance fund over a 7-year period. A UK chartered accountant by qualification, and serving as the first female chairperson of the South African Restructuring and Insolvency Practitioners Association. Jo is passionate about creating sustainable value for her clients. Please, a round of applause for Jo, please. It's a pleasure having you, Jo. So we are moving further to Ms. Mimido Abako, who happens to be the head Insolvency Unit, Federal High Court of Nigeria. Her legal career commenced in private practice at the law firm of Bernard Hom, SAN & Co., Benue State, where she worked from 2011 to 2022. In 2022, she joined the Benue State Ministry of Justice as a senior state counsel, serving in the Department of Citizens' Rights and Mediation Center until 2023. In June 2023, Barrister Mimido Abako was appointed Assistant Chief Registrar at the Federal High Court of Nigeria. Later on, she was posted to the Department of Litigation, where she distinguished herself in several leadership roles. She's a member of Chartered Institute of Arbitrators and, of course, a member of BRIPAN. Please, a round of applause for Ms. Mimido Abako. A round of applause for her, please. Please remember that I said earlier that if you want their full bio, you can find them on pages 39, 40, and 41. Now, the last but not the least is Olasani. Olasani is a corporate finance fintech lawyer at White & Case LLP, a global law firm headquartered in New York, whilst currently based at the White & Case Dubai office. He has also worked in the firm's London, Frankfurt, and Abu Dhabi offices. Alongside his transactional practice, Ola counsels clients on financial regulation in the UAE. He's a regular speaker on finance and fintech issues and has published several articles on fintech, digital assets, and corporate finance. Please, a round of applause for Olasani. Can we have him on screen, please? Nice having you, Ola. It's a pleasure to have you. So we are moving over to our chair for this session, and he's none other than Mr. Ayodele Akintunde, SAN. He is the senior partner He is a senior partner in the law firm of Ayodele Akintunde and Co., a full-service law firm with offices in Lagos and Abuja, Nigeria, where he heads the litigation and alternative dispute resolution unit. He's a chartered arbitrator, a fellow of the Chartered Institute of Arbitrators, United Kingdom, and a mass chartered arbitrator, a fellow of the Institute of Construction Industry Arbitrators, a fellow of the Business Recovery and Insolvency Practitioners Association of Nigeria. Please, a round of applause. Lest I forget, Mr. Richard Ayodele Akintunde was the past president of BRIPAN from 2021 to 2023. Please, let's make welcome Mr. Akintunde to come and take over this session. Thank you so much for having me.
Thank you very much, Cynthia, for the excellent job that you have been doing. A very good afternoon, the President of BRIPAN, members of Council, distinguished delegates, the press. It is my privilege and honor to chair the final session of the 2025 BRIPAN Annual International Conference. And I want to say that this has been one of the most enriching conferences BRIPAN has held in many years. I think we should give this a very good round of applause. Today, we are going to be talking about, or this session is about, something that is very dear to the heart of BRIPAN. Professional ethics, career development. As we all know, BRIPAN is the leading trainer of insolvency practitioners in Nigeria. And over the years, we have played a significant role in improving the practice of insolvency, restructuring, and also standardizing that practice. And also, we've done a lot of work in law reform. The theme of this conference has been deepening insolvency tools for resolving commercial and financial challenges of business. This session will further look into those tools that we can use in insolvency resolution. And we have a stellar panel to deal with the topics of this session. They have been introduced, so I will not say too much about their qualifications, but I will just talk about the topics that they will be dealing with. Mr. Olushaye Opasanya, Senior Advocate of Nigeria, partner Olaniwan and Ajayi, will be talking to us on balancing asset recovery and business continuity in rescue processes. I'm sure many of us want to know how to balance asset recovery in the business rescue space. I remember a couple of years ago, I was in a room, I was visiting a former managing director of a bank in Canada, and he had in rescue processes. He has 25 minutes, and each of the speakers will have 25 minutes
Recording in progress.
Make their presentations. After that, we will have an interaction, and then we'll throw it open to the floor for Q&A. And they will also have the opportunity to give their final words. Once again, I welcome our distinguished speakers. Can we give them a round of applause again? And this session, I assure you, promises to be very interesting, enlightening, enriching. And please, get your questions and answers ready. Some of you can post on the chat box, well, there'll be an opportunity for you to take the mic and ask your questions. Thank you very much. Over to you, Mr. Okpasoya, Senior Advocate of Nigeria.
Thank you very much, Chairman. It's a great privilege to be invited to share my experience trying to rescue the undoubtedly the largest indigenous airline in Nigeria. I don't know why I was chosen, but I doubt that it was because of any extraordinary qualification. I salute every one of you, especially the leadership of BRIPAN. My hope is to learn from you, and therefore I'm looking forward to having an interactive sessions. I like what the chairman said. To recover debt from an insolvent company is like trying to be like Moses. But I believe, particularly for those of us that are Christians, that the Spirit of God enables us to do much more than what Moses did in his own time. For all of you who have been flying ARIC, on behalf of the ARIC team, I would like to say thank you for the confidence, because it takes extraordinary confidence to fly the plane of an insolvent company. But one thing that I assure you of is that what you have been able to do in ARIC is not on account of my own efforts, but on account of the extraordinary efforts of well-trained Nigerians. Well-trained by Sir Johnson and his team. And anywhere I go, I don't behave like Nigerian politicians. That the only thing they have to do is to criticize their predecessors in office. Sir Johnson left behind well-educated Nigerians in all aspects of a good airline. I mean, that begins to show you that there are different reasons why a company will become insolvent. And if you are appointed by a security or a creditor that has security, what I will encourage is that the first place to start in these balancing efforts is your security documentation. What is in that document? What kind of powers does the security documentation vest in the creditor? We all need to appreciate that because there are different types of loans that can go bad, and there are different kind of security instruments that can confer authority to appoint receiver or receiver manager. If you don't want to make mistakes, one of the decisions that you need to
Recording in
take
progress.
very quickly is whether consultation with your appointers. Consultation with your appointers. And I say that because an insolvent company needs money to survive. You cannot, even if you are who was appointed disciple, anointed disciple, whether you are Peter, whether you are Paul, the Holy Spirit won't give you money. What the Bible says is that I will give you grace to get wealth. So money has to be created in order to run an insolvent company. And the most viable source of that money is the person that has appointed you. In my own case, in Lone Star, in ARIC, it was clear from the outset in 2017 that we needed money in order to continue operations. So AMCON provided 2.5 billion. But in order also to give confidence that we were not in a hurry to steal money, Mr. Kamilu Omokide was seconded to take charge of financial matters. So that we did not spend a kobo that was not approved out of that 2.5 billion. And thanks to God, the operations generated multiples of that money, and we were able to repay AMCON. I'm not sure. Well, I thought I saw slides. Yeah, so we can go according by the slides. Debt recovery within the, within the receiver's mandate. It's a contradiction in terms. For you to be charged with the responsibility of recovering debt and at the same time managing or rescuing the business. So right from the word go, I made a point to, very clear to AMCON, that repayment of their debts cannot be the topmost priority. There are priorities. One of the priorities of an airline is your safety and my safety. So in that cascade, the first thing is safety. And therefore, with the team, we decided no aircraft goes into the air unless we are confident that it will go and return safely. So there's no room for risk. Now, the other thing of significance is that you need to appreciate that in an insolvent company, different interests come to play. You cannot continue running a business without happy personnel. If your workforce are unhappy, you cannot recover money, let alone rescue the business. So from the word go, AMCON agreed that its interests come safety, the workforce. One other stakeholder, AMCON, they call it a bad bank. So it's not a bank in the strictest sense of it. And therefore, it must be willing to subordinate its interests, that their recovery, to the interests of other creditors, which also has security interests. The fleet of ARIC is very large, and therefore each of those assets has different security interests and security type. In that bucket, you have lessors. So it's not every aircraft that you see ARIC Air or Air Peace or Air this or that belongs to the airline. Many of them are on lease. And I'm sure you and I know that on lease, the lessors have a right to terminate the lease and recover the assets. So one of the things that you need to educate whoever appoints you on is that you will not, for any reason, stand in the way of others that want to exercise either security rights or ownership rights. They compete, but as a lawyer, and I hope most of us are lawyers, you should not be associated with inhibiting the enjoyment of contractual rights of others. So when we took over, there were some aircrafts under lease. ARIC was in default of rentals, particularly aircrafts that we use for international operations. They approached us. They wanted to recover their assets. Of course, I mean, it was the first thing I did. Please, take it. We didn't even have money anyway to sustain the international operations. Oh. Because we speak in court, I'm sure you can. I'm trying to pitch my voice, so without the microphone, people can hear me. But, oh, okay. I'm a village man, so forgive me. But talking seriously, we allowed lessors to repossess. There are some lenders that had legal mortgages. On approach, we allowed them to exercise their legal mortgage rights. Because in any case, there was, if you are familiar with airline operations, there's an instrument they call IDERA against Cape Town Convention. When it's presented, you are obliged to cooperate. So we cooperated. There is another financing scheme. My brother said he was in Canada by Export Development Corporation of Canada. They approached us, they wanted to recover their assets. Take your assets. Now, what this does is that it does not only enhance your integrity as a practitioner, it's also when you take wrong decisions, you are affecting the creditworthiness of your country. Now, I had said, look at your security documents, because more often than not, particularly when you have a syndicated facility that is supported by a trust-based security instrument, lenders generally agree on how monies recovered should be shared. I can see one legal advisor in my time, nodding. In an attempt to recover money for your appointer, make sure you take care of other interests. That's the point I'm making. Particularly if you can satisfy yourself that the interests of such people rank higher than that of your appointer. Structural and practical challenges. I can tell you free of charge that the workers in ARIC are very happy. I mean, that one, free of charge. From the cleaner to the highest paid, they are happy because, as I said earlier on, without them, there is no revenue. You also need to make sure that the flying public, depending on the asset that you are running, are also happy. I mean, imagine you get to checking counter and the guys that you are dealing with are frowning or asking you for bribe or doing unholy things. So those people are the flying public, depending on where you are. I mean, I once had the privilege of managing an oil rig company. And for me, in that sector, the employer, which were, owners of OMLs, were important. Without them, you cannot generate money to pay any creditor. One practical challenge, which I think BRIPAN must take note of, is the law enforcement agents. Whether you like it or not, they are stakeholders, and they are very important. And so the leadership must make conscious efforts to educate that group of people. Well, I mean, it has gone down now, but when we started, the investigating officer can call you at ungodly hours. Everything we try to do, they are wrapped up in the garments of crime. You want to take out an asset for repairs. They say they are investigating it. It's a subject of investigation, and therefore you can't take it. You want to pay Mr. X, somebody will go. So they are very important. Now, one important stakeholder also is the shareholders. And I would like to emphasize that receiver managers are not owners of the business. No matter how powerful or educated you are, all the law allows you to affect is the directorship power, management powers. So, in managing that group of people, there has to be forthrightness and have to, whether they recognize you or not, you need to recognize them as a stakeholder. Now, the issue about whether I receive of how many minutes? Oh, time up. Okay. See you. See you. Since then. You say it's time up now. Well, but, you know, talking seriously, yeah, you are appointed by AMCON or a bank. But, you know, the law does not regard you as the agent of that person. The law regards you as the agent of the person on whose behalf you are appointed. I'm sure every security document you come across has a power of attorney. Donated by the borrower to the creditor. So when that power is exercised, when they are appointing you, the lender is used in that security document. So, which implies that you are actually appointed on behalf of the borrower. The borrower is the company. And that's why, for me, it's important that you do not allow the person who made you the receiver to oppress other lenders. Because those other lenders will be able to maintain an action against you in respect of the decisions that you take as receiver manager. I do hope I can close at this point. We're still going to have question and answer. God bless you.
Thank you very much, Mr. Sheyo Okpasonya, SAN. Can we please give him another round of applause? He has given us an insight into his experience, real life case of Arik Air, and how he has so far been able to balance debt recovery and the continuity of the business. Are still Arik Air, even though they every two hours. But we thank God that the airline is still in business, courtesy of the good work of Mr. Okpasonya. He has spoken to us about so many things that,
Recording in progress.
that the receiver manager must do to determine whether he wants to continue the business. Look at the documentation, look at the financial health. I'm sure in all this, you must engage experts who are going to look at various aspects and then develop a business strategy that can work to ensure that you can continue the business. He has also emphasized the importance of staff because
my presentation. Let me share that on the screen with you. So I can go into presentation mode. There we go. Can you see the presentation? Hope so. All right, good afternoon to the President of BRIPAN, members of Council, distinguished guests, and ladies and gentlemen. As I have been introduced, my name is Jo Mitchell-Moret. I lead our Africa Turnaround and Restructuring Performance Improvement team at Deloitte, and that is a real privilege. I've held that position for the last 6 years. It is really a privilege to be speaking with you this afternoon. It is afternoon in Nigeria. I happen to be in Tokyo at the moment, and so it is very much a late evening for me. So please bear with me if you think I'm looking rather tired. I am. It's been a very long day. It is a privilege to be here amongst colleagues who share a common mission, and that is to help businesses, help creditors, their employees, and communities navigate the turbulence of financial distress. Insolvency is often thought of as the end of the road, but in reality, it is a mechanism for renewal. A well-functioning insolvency system is a stabilizer in the CAMA Act. We are seeing governments and courts recognize that insolvency procedures are not just legal tools, they are economic levers. When they work well, they recycle capital, protect jobs, and restore investor confidence. When they fail, the consequences ripple across supply chains, households, and financial systems, and indeed can call the very credit system in our economies into question. What we are seeing is also an increasing convergence of frameworks. So the adoption of the ancestral model law, for example, restructuring first approaches. So certainly what we see in South Africa is a court leaning more towards a business rescue in our legislation as opposed to a liquidation, provided that there is a reasonable prospect of rescue. So it is more restructuring first as opposed to liquidation. And even the establishment of dedicated insolvency courts. In South Africa, we have recently, in April this year, launched a pilot insolvency court in Gauteng that is running very well, and we are very excited in terms of what that means for our country and the hope that the pilot is rolled out to many more provinces. The second key trend is macroeconomic drivers of distress. And I think this we can all attest to and are feeling ourselves. So this trend is really shaped by economics. So across the world and here in Africa, companies are under pressure from a combination of forces. This might be high interest rates and tighter liquidity. Many businesses face refinancing walls that they cannot scale. The ability to refinance is getting harder and harder for many businesses in Africa. Currency volatility, so a particularly acute challenge in import-dependent economies, and I know relevant for Nigeria as well. Energy and commodity shocks, from oil to steel to food supply chains, volatility is unfortunately our new normal. Geopolitical fragmentation in terms of sanctions, trade disputes, regional conflicts, they're all reshaping markets. And for us, this means that insolvency practitioners need to be economists, accountants, able to interpret all of these financial signals as well as legal texts. If we move to the third key trend, and this is a shift in the legal and procedural frameworks, there's legal innovation taking place. So if we look at some of the more developed markets and recent legislation that has been passed, we see new concepts from certainly from an African perspective. So we are witnessing profound legal innovation. So the idea of a cross-class cram-down, confirming restructuring there is some creditor classes dissent, has become a very powerful trend in the UK, EU and beyond. The principle of new money priming, where fresh financing can take priority over existing secured creditors, is also becoming more accepted. And perhaps if I just pause there, the concept of priming is something that, from a Deloitte research perspective, we are looking into as to whether that can be applicable within our business rescue legislation. It is naturally, it creates a lot of controversy, but we certainly believe there is a way in which it can be achieved with the protection of secured creditors, because the challenge we always receive is that this undermines the very credit foundation of our economy, and we believe there is a way to do it, looking towards the US model of adequate protection. Importantly, as I've mentioned earlier, the courts are becoming more specialized. So the pilot dedicated insolvency court that we have in Gauteng in South Africa is an example of how efficiency, speed, and judicial expertise can transform outcomes. And perhaps just to pause on specialized courts and to take you through what we are seeing at the moment. Typically, if when we were dealing with business rescue, insolvency, perfection of security cases in South Africa, those could take years to resolve. We now have a system in place where matters can be launched in a court, and we should have a decision within a month. And just what the ability and the efficiency that brings to the cases is. It's been such a breath of fresh air, and it really, the urgency that we know exists in these matters to be delivered by the court as well. It's always, the court was previously always a bit of a stumbling block for us, and a way in which to slow down a process. Now we have specialized judges hearing our cases and understanding the urgency and being able to deliver a judgment in a much more expedited time frame than what we were used to. So digitization, I think, is also important to mention here. That's also game changing. So, e-filings, virtual creditor meetings, I'm sure we've all had to do those, and faster transparency are also reshaping expectations in our profession. The financing of distressed companies is my fourth key trend. It is no longer just banks that finance distressed businesses. we're looking, I will say that there haven't been very many successful distressed funds emerge out of South Africa. We have seen more deals completed with the international distressed funds. But just looking at the amount of interest, looking at some of the investment cases that have been put in front of me, I am quite sure that this is a new class of finance that we will see a significant increase in the years to come. I think it's also just from an African perspective, it's understanding what role our development finance institutions can play in this space. Again, there has been a lot of talk from a South African perspective about the notion of putting together a post-commencement finance fund that is a collaboration between different development finance institutions. And what a game changer that would be in distressed situations. It would really, I suppose, that type of a fund with development finance would be blending both commercial and developmental objectives. For me, that offers hope for rescue funding in markets, particularly where private distressed investors may be cautious. When I say it's no longer just the banks, sometimes it is the banks that have a hard time in terms of financing distressed companies. They do so on a spend to save strategy. So having a DFI-led distressed financing credit fund would be a very interesting development in our market. So moving on to my fifth key trend in restructuring. And that is the tension between an informal process and a formal process. What we are seeing is really a rise of what I would call hybrid restructuring processes. The challenge being that if you do purely informal processes, there are challenges with creditor coordination issues. You need all the creditors to play ball. One of them breaks rank, and then you find yourself in a formal situation. If you're looking at purely formal, too rigid, slow, particularly with court involvement, and very costly. So what we are seeing on the increase is this rise of a hybrid type restructuring process. And I suppose the UK Part 26A restructuring plan really being a very good example of a hybrid. Those are consensual negotiations that happen outside of the court, but ultimately are sanctioned by the court. Repack administrations being another one. Negotiations taking place outside of a process and then moving into the process for implementation. I certainly believe that pre-pack administrations are an area of great potential for Africa. Unfortunately, the business rescue legislation in South Africa doesn't necessarily provide for a smooth pre-pack process. There is a way to do it. It just isn't as efficient as I have seen it from an operation perspective in the UK. But this is something I think we need to think about, particularly for the consequences of trying to trade in an administration. Consequences, for example, being the impact on a working capital cycle. Particularly loss of customer confidence. So the more efficient you can be in terms of getting a deal done, the better. And that's why I think looking at a way in which we can facilitate pre-pack administrations, as well as mitigating the obvious risks that come with it, very important for us moving forward. So the sixth trend really has to be technology and data in insolvency. I think technology really is no longer optional. AI and data analytics are helping practitioners to trace assets, to reconcile claims, and to detect fraud. Virtual processes, for example, your creditor meetings that are being held online, your filings via digital portals are all reducing cost and delay. So I know we have spent a lot of time at Deloitte looking at these platforms in terms of bringing efficiency to the processes that we run. And I have seen some incredible developments in case management. So I think that's definitely also a one to watch. I think, there's always risks and opportunities, and perhaps the risks of technology really lie in the cyber risks. So distressed entities are generally, practitioners need to safeguard sensitive data during a sales process or the restructuring. And this is a space where I think Africa practitioners can leapfrog. They can adopt best-in-class digital solutions without some of the legacy burdens that the more developed markets have. And I would love to see Africa leading the charge in this regard, taking heed of these cyber risks and looking at ways at which we can mitigate them. My 7th key trend is dispute resolution. And if you are a member of Insol International, you will see this is also something that they support. From a SARIPA perspective, and SARIPA being the South African Restructuring and Insolvency Practitioners Association, we have sat down with our arbitration council in South Africa, and we have collaborated together to craft clauses that can be incorporated into business rescue plans that allow for dispute resolution mechanisms, for example, in claim determination, which keeps those matters out of the court. And I think that from an efficiency perspective is very important. It also reduces the cost of the process if you are adjudicating or looking at disputes around through arbitrating the matter to court. I think any way in which we can free up court time is critical, and that allows also a much more speedy process to resolve these particular. So my 8th key trend is policy and regulatory developments. Across the continent, I think we're also seeing an evolution. So early warning systems, really encouraging directors to act before insolvency. If we could get this right, I think every insolvency practitioner would be delighted. Simplified small enterprise restructuring tools. So recognizing that small businesses need accessible and affordable procedures. I have, again, if you are a member of Insol International, there was a technical paper released recently that looked and compared and contrasted 3 different regions and the procedures that are available to SMEs in those regions. It's one which we grapple with in South Africa. Business rescue is a costly process. It is not one that is necessarily accessible to smaller companies. We also don't really have a process that is accessible for unincorporated businesses. So looking at ways in which this we can develop policy in relation to SME and their rescue and renewal, for me, is very important. From a
Recording in progress.
Reforms for me signal a recognition that insolvency is not just a legal process, but it is an economic policy priority. My 9th key trend is really insolvency as an engine of renewal, which is vital in an African context. Ultimately, for me, the biggest trend is the reimagining of insolvency's role. It is, I said at the beginning of my talk, it is no longer viewed purely as sort of liquidation and closure. It is now seen as a pathway to renewal. Done well, as I mentioned earlier, it protects creditors, it preserves jobs, it recycles assets, and it restores trust. In Africa, for me, this is particularly vital. our economies cannot afford the destruction of value that comes from weak or underused insolvency frameworks. I think, particularly again speaking from a South African perspective, we have not seen enough law reform. So when we identify challenges within our insolvency legislation, both and a business rescue perspective, we are too slow to make the necessary amendments to our legislation. Because for me, how important these systems are, we do need to also be efficient in our reform. So that brings me to the last key trend, which is really the future outlook. So really, what lies ahead? I think we can expect more cross-border cases as African corporates raise debt globally. That's going to bring challenges to the matters that we preside over. We will be seeing multidisciplinary insolvency professionals. We already see that. So blending law, economics, finance, ESG. We always talk about the insolvency practitioner needing to wear so many hats. And the key for me is always identifying what you don't know and bringing a specialist in. I think there will be a greater push for diverse and inclusive participation, whether that be women in restructuring, younger professionals, and broader stakeholder voices. I think it's important to create forums where women, younger professionals can also have a voice in restructuring and insolvency. Insolvency for me is becoming much more complex, it is more global, and it is more impactful than ever before. So then, just in closing, colleagues, the world of insolvency is not static, it is dynamic. And we are seeing that in the number of legislation reforms across our continent. However, each economic shock, each regulatory reform, each distressed case teaches us new lessons. As practitioners in Nigeria, in South Africa, and indeed across Africa,
she's talked about the issue of
Recording in progress.
Post-commencement financing, and I think Mr. Okwasanya also mentioned that, because that is the lifeblood of any successful restructuring. And she's also talked about new sources of funds. For instance, Mr. Okwasanya was lucky that AMCON was ready to give the 2.5 billion naira for the business to continue, but she's talked about such as hedge funds, private credits, and specialist distressed investors. So we now have people who specialize in investing in distressed assets. She's talked about the shifts in the legal framework, such as specialized courts, also efficiency, speed, capacity building, and things like that. She's also talked about the shift to the multidisciplinary insolvency practitioner. So we're now talking about insolvency practitioners who specialize in aspects of insolvency and not just general insolvency practitioners. So once again, we thank Jo Mitchell Marias for her presentation on emerging trends, opportunities, and challenges. One thing she talked about was the specialized courts, the efficiency of the judiciary in the insolvency process. And today we have with us Ms. Mimido Abako, who heads the insolvency unit of the Federal High Court of Nigeria. A few months ago, the Chief Judge of the Federal High Court established the court's insolvency unit to enhance efficiency in the service delivery of insolvency cases. The unit has responsibility for ensuring implementation of insolvency processes and providing insolvency practitioners with a dedicated channel for supervisory and enforcement
services. I'm sure many of us have heard about that insolvency unit, but she's here today to give us more details on how that insolvency unit works. I invite Ms. Mimido Abako, Head Insolvency Unit, Federal High Court, to give us her presentation.
Good afternoon, everyone. Please permit me to sit down and present my paper. My appreciation goes to the executives of BRIPAN for this rare privilege. Thank you so much, sir. I'm speaking on the guide to the operation of the new Federal High Court Insolvency Unit. The Insolvency Unit of the Federal High Court was created on the 27th of February, 2025. The global economy is increasingly interconnected, and with this comes the inevitable challenge of business failures, debt defaults, and insolvency. Effective insolvency regimes have proven crucial in ensuring financial stability, promoting economic recovery, and protecting creditors. The Federal High Court of Nigeria, who is vested with jurisdiction over insolvency matters, has recently established a specialized insolvency unit. It's the reason why I'm here, and I'm presenting this paper on the guide to that unit. Section 251 of the 1999 Constitution, as amended, has empowered the Federal High Court. And because of this power, it thought it wise to create this unit, thereby embracing global best practices in specialization, efficiency, and expertise in commercial adjudication. So the concept of insolvency cannot be overemphasized, and the importance of insolvency in the legal profession lies in its role in creditor protection, debtor rehabilitation, judicial oversight, economic stability. So the insolvency unit is administered under the authority of the Chief Judge of the Federal High Court, with delegated powers through the head of insolvency unit. Its administration is anchored on transparency, efficiency, and accountability. So key features of the administration of this insolvency unit includes case management system, which has to do with digital platforms for filing, tracking, and monitoring insolvency cases. Then we have specialized training, mandatory training for judges and staff on insolvency law and practice. Permit me to pause here to mention the fact that the president of BRIPAN had a few months ago held a meeting with my Lord, the Chief Judge of the Federal High Court, to ensure this is done. We still look forward, sir, to your coming back to Federal High Court, because this is very important. I would like to also request that by the end of this year, we'll be having our legal year celebration. It will be very apt for you, sir, to have a meeting where the gathering of all the judges of the Federal High Court in the 36 states of Nigeria will be present, and we would love that there will be a presentation from BRIPAN. I will follow up on that. Thank you so much, sir. Then we also have stakeholder engagement. That's collaboration with the Nigerian Bar Association, banks, regulators such as CBN and SEC, and insolvency practitioners. I was also invited some months ago by the section on business law practice to meet with them. We had a meet and speak event and trying to get to know what the insolvency unit is all about. We do appreciate that invitation, and we look forward to further collaboration with the MBA to enable us and see how this unit functions well. The structure of the unit has the head of unit. It also has a judicial desk, judges who are handling insolvency cases. Particularly we have Court 5 at the headquarters, who is handling the insolvency cases. And then we have other courts here in Lagos State, where my sister Vivian Anozie has been pioneering well on insolvency issues. We have case management officers, we have legal research officers, we have the registry and documentation officers, finance and audit desk, then the ICT officers. I have about 11 staff who are working with me in the insolvency unit. So while we talk about insolvency issues in this conference, we are looking at how we can actually do our work with integrity. So the staff conduct is critical to the credibility of the unit, and our guidelines are confidentiality, impartiality. Everyone who comes to the unit is treated the same. We do not see you, you're big, you're small, or however you appear. We treat you equally. So there's professionalism, upholding integrity and adherence to procedural rules. We also have efficiency, timely handling of case files and applications. I had an issue. A file was remitted to the enforcement unit when I called for a meeting of both the lawyers to the creditors and then the debtors, and they all came. But one particularly, I called, he said, okay, I will be with you, and he didn't come at all. And up till today, he has not said anything or come to the unit so we can end this matter, which will be concluded in court finally. This is actually not good. If it's coming from we lawyers, it's actually not good. We should help the unit. If you are called upon to have a meeting, please ensure you come so we can have this meeting and deliberate appropriately. What joy do you have in seeing that the creditor doesn't get his due? It's not good. I'm sure those who are in that kind of lifestyle will stop. Thank you so much. Okay, then we have ethical standards, compliance with the code of conduct for judicial staff, which keeps us to do our work professionally and ensure that every file that comes to us is treated confidentially. We don't have any reason to take matters out of the unit to begin to discuss them. So how our income is generated is through the filing and court fees, then payments of e-filing and online access. We are looking forward to a regime where we can go online at the comfort of your offices. You can file your cases and they will be treated expeditiously. Then we have training and certification, annual publications, partnerships with agencies and financial institutions. Then we have recommendations for the new unit, capacity building, regular workshops for judges and staff of the Federal High Court. Permit me to say, sir, Mr. President, that members of the insolvency unit have indicated interest in insolvency training. I hope that will be done. Thank you so much. And then we also look forward to the training for our judges of the Federal High Court, so that a lot of them, remember when you first came, you noticed so many of them didn't just flow with what was going on. And I think empowering us, particularly the judges, is very crucial so that your matters can be attended to expeditiously. Thank you so much. So legislative alignment. harmonization of insolvency procedures under the CAMA 2020 with the Federal High Court rules. We will work hand in hand, sir, to ensure that the practice direction for insolvency unit is merged with our Federal High Court rules. Thank you. Then digital transformation, full adoption of e-filing case tracking systems. Then institutional integrity, strict enforcement of staff ethics and anti-corruption measures, and international collaboration. We seek partnership with foreign insolvency institutions. We've been listening to our foreign participants for knowledge sharing. That will be beneficial to the unit and it will help us. So in conclusion, the creation of the Federal High Court Insolvency Unit is a landmark step in strengthening Nigeria's commercial justice system. Properly administered, structured and supported with modern tools, the unit has the potential to transform insolvency practice in Nigeria, aligning itself with best practices by ensuring transparency, efficiency, and sustainability. The insolvency unit will not only enhance judicial efficiency, but also foster economic stability, investor confidence, and long-term growth in Nigeria. Thank you so much.
Thank you. Please, can we give her another round of applause? She has taken us through, she has given us a guide to the operation of the new Federal High Court Insolvency Unit. And I'm happy with the collaboration so far with BRIPAN and the fact that there will be more collaboration. Be rest assured that we at BRIPAN are ready to assist the insolvency unit in building capacity and also in improving the processes. Many of us continuously face challenges concerning speed, whether it is to hear insolvency-related cases or even after obtaining orders, enforcement of such orders, they continue to generate a problem for us. I thank Vivian, Federal High Court Lagos. She's been doing a fantastic work to ensure that insolvency matters are expedited. And be rest assured, we will hold your hands to have a joint success. Thank you very much. A round of applause again for Ms. Mimido Abako. The final presentation for today is going to be very interesting. I want to do a poll, show of hands. A poll, show of hands. How many of us, or who here has used artificial intelligence to resolve an insolvency? Any aspect of the process, whether it is in summarizing documents. Many of us have used ChatGPT in one form or the other. Has anybody used artificial intelligence in the resolution of any insolvency process? The only person here is Mr. Akinwumi. We have our work cut out for us. And Mr. Olasoni, an associate in White and Case LLP, is vast in this area. He'll be speaking to us today on impact of artificial intelligence and innovation on insolvency practice and processes. Mr. Olasoni, are you with us?
I am indeed. Hello, everyone. Give me 1 second. Let me just sort out my screen. Okay, well, good afternoon, everyone, and thank you to BRIPAN for the invitation. I'm joining you virtually here today from Dubai. So today I'm here to speak about something that I think is both practical and very timely, which is how AI and innovation can make insolvency work faster, more accurate, lower cost, and more transparent, right? And by the end of this session, my aim is to really make it clear what the value proposition of AI is and how, and to give you guys a clearer view of how AI can fit in within the insolvency life cycle and to empower you to take at least one small step into integrating AI and innovative technology within your next matter. So I'm very grateful to be contributing to this conversation, and I'm sure it's a conversation that matters and will continue to matter for practitioners, judges, and professionals in this industry. So let me just move on to the next slide. 1 second. Okay, so by way of introduction, I'm Olasani, and for the last 7 years, I've worked as a finance and fintech lawyer at White & Case. So I'm based in the Dubai office at White & Case, but I also worked in our London and our Abu Dhabi and Frankfurt offices. So my focus is primarily on corporate finance, which is essentially helping companies raise money from international investors and tap into the international finance markets. So we've advised the Federal Republic of Nigeria, the Republic of Ghana, Saudi Aramco on international transactions. And then on the fintech side, I work with fast-growing companies to help them translate their visions into reality. So we assist with international expansion, licensing strategies, and we help fintech companies navigate the fast-moving regulatory environments in the fintech sector. So in short, I work at the intersection between finance, technology, and regulation, which is why I care deeply about how AI can really help improve outcomes, not just in theory, but in practice. So the aim of this session is very, very practice focused, and I really hope to shed some light into how you can really start embedding AI into your various workflows. So without further ado, let's look at the agenda. So we will start by exploring pressures we all feel and what the what the 4 KPIs that should really matter when we're talking about AI, which I think are speed, accuracy, cost, and transparency. We will then discuss, how to really stay ahead, the different ways in which AI can fit into your insolvency life cycle. We will explore 4 different use cases that you guys can just to really exemplify this message that we're making right now. Some tools, some practical tools that you can start using to embed AI within your workflows. Then towards the very end, we will go over the risks and guardrails that as practitioners we need to really be aware of in this area. So why now? In my mind, I think there are 3 simple pain points that we see daily as practitioners and professionals that really exemplify why we should start taking AI seriously. I think the first is complexity and volume. Right? Transactions can often be complicated with more documents, more data, more counterparties. Second is administrative drag, which comes hand in hand with complexity, meaning we spend a lot of our valuable time on processing rather than judgment. third is coordination cost. Since we often see dispersed creditors, cross-border elements, adjournments, but now I have to manage expectations. AI, of course, will not help solve everything, but it can be very, very effective in the at three things that we need, which is one, automating the routine activities so that teams can actually spend less time on mundane activities and more time on the things that really move the needle. Second, surfacing risk at a much earlier stage. So conversations can start happening with more runway and resolutions can surface much earlier. And finally, organizing unstructured information so that the story that as practitioners we're presenting is clearer to the various stakeholders that we're dealing with. So to keep us grounded, I'll frame everything around 4 KPIs: speed, accuracy, cost, and transparency. If an AI workflow moves at least one of these 4 KPIs, then in my opinion, it is worth considering and could potentially be a very strong candidate to embed in your next matter. So the reality is that AI is quickly moving from being a niche form of differentiator to what I would even dare to say a mainstream and an expected capability. And my prediction is we will continue to see this trend in the next few years. And across professionals, including in the legal profession and insolvency professionals, clients are now keenly assessing efficiency and transparency in the delivery and execution of transactions. So the question is now becoming not how do you or like if you adopt AI, right? It's which AI you're going to adopt and how will you apply it. So AI can become a force multiplier to your existing capabilities. In order to really for those of us who have not yet started exploring this area, I would advise you start small. You pick one workflow, perhaps one that's high volume and repeatable. You measure and you decide in advance how you would judge success, whether it be how many hours you've saved, the error rates, fewer adjournments, and then you keep human beings in the loop, right? Because you have to recognize the capabilities and the limitations of AI. Hence, maintaining human oversight is a very important element towards the utilization of AI. So now, let me set out a simple map that we can all visualize. Just so I can really map out where AI can really fit in to the insolvency life cycle. Starting from pre-insolvency, filing, administration, claims and voting, plan, approval, distributions, and monitoring. So pre-insolvency, AI tools can help monitor market news, signals, and basic covenant ratios metrics to allow you to spot stress signals earlier whilst the options are still available and before things get mission critical. When we're looking at filing and administration, there are several documentary AI tools that can really help you getting on top of the oftentimes heavy documentary burdens that insolvency cases may have, and as practitioners we may encounter. Looking at claims and voting, AI can help assist with that process as well. Likewise with plan approval, distributions, and monitoring. So the principle is simple. Place AI exactly where your bottlenecks are. It doesn't have to be everywhere. We're not telling you to throw out all of your processes and replace them all with AI. I think we have to be sensible. But I would encourage really starting to identify where within your workflows, and where within the insolvency life cycle you can start experimenting and hopefully adopting AI. So now let's go over some use cases for AI, just to really put this into practice, right? The first practical move is early warning, which in plain terms, it means using AI to keep an eye on the market signals, so you can really spot trouble much earlier whilst you still have options to resolve things. So here's what this could potentially look like in practice. You can utilize an AI technology to watch the basic metrics that you care about, whether that be covenant headroom, cash flow trends. You can incorporate a short feed of market or regulatory news about the company and its key counterparties. AI can assist you with highlighting changes, not just the noise, but the key changes that you care about, and putting it in front of you. And then as human beings and as overseers of AI, we can review and assess, and then that can allow us to make a decision at a much earlier stage. So the key is to start by experimenting small. You don't need to revamp everything. But with the assistance of AI, you can start to spot early insolvency signals and get ahead of it before it gets critical. Moving on to the second use case is clearing documentary backlog quickly. So as I said before, many insolvency matters are documentation heavy, and AI can really be a powerful partner in doing the heavy lifting, so that your team and as professionals, we can focus on the matters of judgment and strategy. To put this into context, AI can turn scans, and to get really granular about this, AI can turn scans and PDFs into searchable text, whereby you can then focus on the key information you need. And as humans, we can then come in and review the key information we need. By seeking ways to embed AI in our documentary review processes, we can move from processes that can practitioners, we can focus on the analysis rather than doing the grunt work of chasing down PDFs and reviewing items page by page. Next, this is where the third use case is claims and waterfalls, which is where a lot of matters really tend to slow down, and AI can assist with helping keep the claims process clean and efficient. So you can, we have seen tools that can allow creditors through, whether it be simple forms to catch obvious mistakes or duplicates, review group claims, and lets you test out different payout scenarios instantly in an insolvency case. So if you're able to run this alongside your current process, or on one matter, you should, in theory, and based on research, you should see fewer errors, a faster verified list for claims, and fewer arguments about the maths when you have a trusted AI technology that really helps on that front. And then for the fourth use case is around bond, sukuk, and e-voting, right? Where you have, which is very, very pivotal in the context of the Nigerian sukuk market, where you have bond and sukuk holders that are spread across different custodians, which means there's paperwork that could slow everything down, and AI-enabled tools can really help make the process a lot smoother, leading to higher participation, more first attempt quorums, and shorter timelines. So let's ground this with two very, very brief case studies: document intake and early warning, to really ground what we're talking about here. So to illustrate what exactly is the art of the possible, let us assume you're working on a documentary heavy restructuring where you're facing hundreds, potentially even thousands of documents in mixed formats. And the goal is simple. How do you dissect the vast information and reach a reliable issues list quickly without burning weeks doing it entirely by hand? As discussed, documentary AI can assist with documentary review. You can incorporate clause extraction steps that can pull out the key provisions that you're looking for, whether it be cross-default guarantees, set-off, and then you can then embed human reviewers to like review and cross-check the work. Based on research, the typical impact of the and mean documentary review timelines shifting from weeks to days, you preparing the first issues list on a matter much sooner, and your team moving away from the mundane administrative review exercises to analysis and strategy, which is what clients really gain the most value from. So now let's look at the second case study. We can imagine a cross-border financing where the signals are subtle, whether it be a drop in certain covenant ratios, a few worrying headlines. The aim is to see the risk early and give yourself more room to act. And this is a low-hanging fruit, a weekly, and you can utilize any of the mainstream AI LLM programs like ChatGPT, for instance. On this, you can set up a weekly AI operated dashboard that can do the work of tracking these key metrics for you, whether it be covenants, cash flow trends, for the relevant party, industry, and counterparties. It will highlight the changes for you, and then as human beings, you can then review, reach out, and assess your options. Okay, it appears my time is up. Thank you very much, guys.
Thank you very much, Ola. I'm sure that during the Q&A, some questions will be directed at you, because I'm sure a lot of people want to know more about how to use AI in resolving insolvency. Please, can we give Ola Sonny another round of applause? I understand we have very little time to round up this session. We have just about 10 minutes for Q&A. And I would now invite distinguished delegates who wish to ask the panelists any questions to please signify. Can we have one of the ushers assist with passing the microphone around? Who else would like to ask a question? Let me just identify. One. Mrs. Anima Shaw. All right. Yeah. 3, 4. Okay. Please ask all the questions. Indicate who you are directing your question to, and then we'll take it up from there.
Okay. Thank you very much, sir. Yeah, so my first question is to Leonard Silk, Mr. Olusegun Pasanya. So I wanted to ask, sir, from an ethics point of view, when you are appointed as an insolvency practitioner in a scenario, what is the relationship between the person appointed and his firm? So, for instance, we know in arbitration it can be an issue. Say writing as innocently as writing a letter on the letterhead of your firm or using the secretarial staff of your firm. Are there ethical issues around how you use your own firm in your insolvency work? And then my second question is for the speaker from South Africa. I don't know if she's back with us, but I'll ask and I hope we'll be able to get the question.
I think she's back.
She's back. Okay, thank you. So the second question, she mentioned specialized investors in distressed assets, whom we also know otherwise as vulture funds, who put money in, but more often than not, their goal is simple. They want to strip assets, or perhaps they want to pursue a prospective claim, maybe by way of third-party funding, that might bring a huge payday. But essentially, bottom line is, all they want is to get as much as they can out of their investment. They are not really concerned about the vehicle still being a live-going concern. So I wanted to ask her, what are practical guides around how an insolvency practitioner will avoid getting caught in that kind of scenario where the investor simply just wants a return and is not interested in rescuing the company. Thank you. My name is Max Ikongwe.
Yes, thank you, Max. I'll take 2 more questions before I'll now take the second set. Mrs. Bola Tumi.
Thank you. My first question, okay, let me start with the short one. The first one is just a request for the AI man to give us the last slide, please. The last slide, I missed it. So then,
technical will give you the last slide.
Okay.
I'm sure they have it.
Please, with regards to ARIC issue, we know now that ARIC, they delay flights, and with this problem that you are trying to resolve for them, is it not getting more complicated now that we have been given the power to sue them if our flight is delayed or cancelled? Will it not complicate the matters, giving them more problems? How do you want to help them to resolve this problem? Because it's another problem. Because when we start going to court for them, delaying our flights, I think that will add to the problem that they have. Thank you.
Then one more for this round. One more for this round. Behind you, my dear sister there.
Thank you, my President Emeritus. Mr. Kwesanwo, thank you so much. That was a master class. But I have a question. Can you tell me if you have any regrets? If you were to do another ARIC again or the oil company, tell us, is there anything you would do differently? Is there anything you wished you had not done? Then my other question is to the gentleman who spoke about AI. How do we protect ourselves against the common pitfalls? AI is blackmailing people up and down. AI is giving people false summaries and sometimes false precedents. Is there anything in place, industry related this time, to protect against those pitfalls? Thank you very much.
Thank you very much. I'll yield to Mr. Okwasonya, SCN, to answer the questions that have been directed to him.
Let me start with delayed flights. You know, the problem with us is that we really don't appreciate much what all over the world flights are delayed. All over the world. Actually, to be sincere, in the last 1 year, it is this group of people that are raising with me for the first time flight delays. Somebody called me from Abuja, I think it was last week Tuesday, and said he was at the lounge. ARIC was delayed, maybe about 10, 15 minutes. I called me to ask what's happening. that because the people waiting for Eric said that was unusual. I fly Eric, and don't tell me it's because I'm on a flight that the flight is not delayed. But you can't fly at this time of the year and you don't expect delays because nobody has control of the weather. Indeed, this gentleman who called me about the flight, apparently the flight couldn't take off from Lagos because of bad weather. I see that industry is controlled. It's highly regulated. I personally don't get involved in operational matters. So when you are thinking of suing the airline, bear in mind that the airline is entitled to defenses. And one of the defenses that is foolproof is weather situation. The air control will not allow any airline to go into the air if the weather is bad. It doesn't matter what the captain wants. They won't just give you clearance. So that's, if you sue, will it worsen the financial situation of the company? I don't know. But I assure you that we've dealt with court cases, and there are many of them under my own watch that has been won. So I will enjoin you not to rush to court without finding out the cause of the delay. Now, Eric and ethics. If you work for AMCON and they appoint you as receiver manager, they actually expect your firm to handle all the cases relating to that receivership. Because what you are paid is not just for managing the company, it is in their head everything relating to the receivership, including court cases. I allow the CEO of ARIC to take charge of farming out of cases. For me, that's an operational issue. It has nothing to do with the receivership. So whoever he likes, occasionally he will consult me and I will provide necessary guidance. But I do not know of any law or rule that prevents the firm, from providing legal services. Do I have regrets? For me, managing ARIC is an uncommon opportunity. I mean, how many companies in Nigeria are like ARIC? It's giving me tremendous opportunity. I've had brushes with law enforcement agents. But, it comes with the tough. What's important is your own personal integrity. I'm not in ARIC to make money. I'm in ARIC to serve and to show international airlines that we as Nigerians, we can do it. That's my drive. In fact, in my first 2 years, how much were we paid when I was leaving? I think it was 25 million by AMCON. It doesn't disturb my legal practice. If I work for ARIC in the morning, I stay up the night to perform my responsibilities to the firm. It just costs you some inconveniences and lack of sleep. But so I sincerely don't have regrets. There has been enormous challenges from shareholders calling you what you are not. But as they say, in Yoruba land, if you visit the river, you can't complain that, you know, your clothes are wet. So I'm actually enjoying every bit of it. Thank you.
Thank you very much, Mr. Okwasoya, SCN. Joe, there's a question to you about specialized distressed investors, specialist distressed investors buying just to strip assets. Did you get the question? Okay, go ahead.
I did. Sure. So thanks, Max, for the question. I think you were saying how do practitioners determine the objective of potential distressed funders into a process? And I suppose vulture funds do exist. We have seen them operate, and I don't suppose that many of us enjoy that experience.
Do you do that for him? So I won't even go to a venture capitalist. And besides, as I said, most foreign financiers don't want to touch you. So if you...
Business for like 37 years, so please forgive me. Now, my challenge, which is why I'm bringing it to the fore, is what is the ethics in-house? Mr. Okwasoya, you cannot doubt the fact that your employers sometimes have their own agenda. And the rules are quite comprehensive and detailed. So how do you navigate situations where, just as we have insider dealings in companies that may want to attack insolvency and the work, how do you handle situations where, in your case, the body appointing you is also trying to disturb best practices? How do you handle it? Because we have situations where some of the assets are even targeted by, and they frustrate the process, they don't come to court, they bring up all sorts of things. So that is also ethical. Please, how do you confront it as an experienced legal practitioner and a receiver?
Okay, thank you. Again, they said in the Bible, they caught a woman in adultery and reported her to Jesus. Should we stone this woman? And they said, Jesus stooped down, started writing, and he said, let the man who has no sin be the first person to throw stone. You see, at the end of the day, ethical issues are personal. You probably know that in 2019, I left Tariq as receiver manager. And when there was change of board, some of them approached me. In fact, the current MD told me when I said I don't want to come back, he said to me, who is not with us is against us. And so I accepted to come back. It's an honor. I don't pretend not to be a Nigerian, and nobody should. AMCON is different from AMCON staff. How do I manage conflict situations? I mean, the way I've spoken to you today should tell you the kind of person that I am. At the end of the day, if you allow somebody to use your name to do wrongs, you will be accountable. So there should be some no-go areas. There should be things you cannot compromise. And I can assure you, at least in my own time in Arik, nobody will use my name to gain undue advantage. That's a personal decision for me. And let people take, I'm hoping, you know, Nigeria is the way it is today because of your actions and my actions. And if it is not directly your actions, it will be the actions of people that you and I know. So don't let us, it's not peculiar to AMCON. Yeah, I'm glad at the court they are setting up a department. But that doesn't guarantee anything. It's not the department. It is people like my sister. It is the judges that apply the rules that matters. And that's why I said it's personal. It's not peculiar to AMCON. Don't let us pretend. There are people in this place. There are some people, when they do insolvency practice, they become warlords. That's, you just take your personal decision. Is AMCON a good tool for recovery of debts? My answer will be yes.
Thank you, sir. Thank you very much, sir. Thank you very much, sir. Without any shadow of doubt, one of the reasons BRIPAN emphasizes on training of insolvency practitioners is to imbibe ethics. I'm sure that those who are going to be inducted today will see that we have a very detailed code of conduct of ethics. We also have a committee that disciplines errant insolvency practitioners. Ours is to standardize the practice of insolvency to international best practices. We don't want to be cowboys. We don't want to be destroyers of business or undertakers. We want to ensure that insolvency is seen not as a terminal situation, but as a way that we can continue to develop the economy. Please let me allow Joe who has joined us again to answer her question. She is way in Japan. You can imagine the time difference. Joe, you have the floor. Speak as much as you want in response to the question.
Cool.
Thank you.
Thank you very much. Let's hope the network lasts this time. My response was that distressed funding is oftentimes vital in a formal process. It is the lifeblood of the process and much needed in order to have success. If I recall Max's question, it was how do you determine the kind of funder you are dealing with? And my suggestion is to always look at the deals that have recently been concluded by that particular fund to understand the type of structure. You can always ask for references and speak to those people who have dealt with a fund before to try and get an indication of future behavior. That's certainly how we've got comfortable in the matters where we have been involved and funding has been obtained not through commercial banks but through a consortium of local and international finance providers. So do a bit of due diligence on the fund who wants to come in to understand what their ultimate objective may be, bearing in mind that it is important that this is a process for creditors. So to the extent that you are able to get a better return for creditors with the use of distressed funding and you understand what that means for the future of the business, it is something you need to consider. As you say in South Africa, post-commencement finance, if there's no post-commencement finance, there's no business rescue. You need the financing available to achieve success. Thank you.
Thank you very much, Joe. Ola, there was a question directed at you. Are you still with us? Please go ahead and give your response. Ola, are you still with us?
Hi there. Sorry, apologies, bad network. So I think, first of all, that's a great question in terms of actually being aware of what are the pitfalls and limitations of AI. And I think any true endorsement of AI as a technology would be incomplete without emphasizing the risks of this technology and the importance of actually having secure guardrails when you're utilizing AI. The most important thing I would say to answer that question is you have to keep human beings in the loop. AI should amplify your professional judgment, but it should not and it cannot replace it, right? So how do you go about this in practical steps? One, you have to ensure that you always keep human beings in the loop. Treat AI like an assistant. It can help you with the mundane tasks that you need. It can also help with research and keeping on top of certain workflows. But it's the human beings that are the key components, and it's the human beings that are still the decision makers, and that cannot be outsourced to AI. Another key thing, which is very topical, particularly in the legal profession, is protecting confidentiality and keeping confidentiality and data protection top of mind, which means when using AI, ensuring that, particularly if you're using open source AI like your ChatGPTs, your Geminis, you're not feeding highly confidential information or client information or sensitive transaction data into public platforms. So knowing the limitations of what you can use AI and to optimize, and what you should be very careful with is important. And then finally, it's being transparent, like actually being transparent and having checks and processes with how you use your AI, particularly since as AI will soon become probably an expectation, which is something I hinted at before. We will soon find ourselves in the future, I predict, in a position where whilst the use of AI in itself might be acceptable, right? But transparency and actually ensuring that the human process and the human auditing has been done to verify, and to ensure that the certain checks and balances that I've mentioned before are in place would be very, very important when you're justifying your usage of AI. So that's how I would answer the question.
Thank you very much, Ola, for your answer. We are going to round this up now, but before I do so, I must yield to my past president, Mr. Seyi Akinwumi. There's somebody also trying to ask a question there. After past president Seyi Akinwumi asks his questions, I will let you ask your question, and it is a wrap. It is a wrap after that.
Thank you very much, Mr. Chairman. Mine is to Mimido. That's her name? Mimido, yes.
Mimido.
Yes. There's been over the years appointments, liquidators in particular, and then in other receivers appointed by courts. And my issue has always been that the officials don't have the competence to carry out insolvency assignments. And yet, in many cases, they're the first line. So in fact, sometimes you have the provisional liquidator, and they're there for months before the actual liquidator is appointed. And by the time you get there, all manner of damage has been done. So when I heard about this insolvency unit, I was very happy. But I'd like to know how you intend to ensure that proficiency is infused into your work. For example, apart from you, are your members here? Members of your units here? They should be members of BRIPAN, and there must be. We focus on training the judges, but I think there's a lot more to do as well in terms of training the members of your unit. And also, is it possible to have some collaboration with practitioners to help you in that assignment? Thank you.
Okay, thank you so much, sir. Let me start from the end. Members of staff of my unit have been graciously allowed to participate in this conference currently. So they are actually viewing online as we speak. So they are part of this conference. And thanks to BRIPAN for graciously doing this for us. Okay, then secondly, we intend that members of my unit be trained in this regard. We are actually working towards that. Gladly enough, the BRIPAN president visited our unit like 3 months ago, and I mentioned this to him. He met with staff of that unit. So we are working towards the training of those staff so they can efficiently deliver well on issues of insolvency. So with regards to issues of receivership, I think most times the court appoints receivership, and then in the case where you have companies appointing their own receivers, we need to let the court know. And with the coming up of the insolvency unit, ours is more of a supervisory role. We are working with the court. Like if we have matters over them, those files are referred to the unit for us to treat so that we can have meetings with the creditors and then the debtors to see where they've been having issues in trying to resolve either their bankruptcy or their liquidation issues and all that. So far we've had like 2 meetings with different cases. I think the third one was the one I mentioned, and put up a notice for meeting, and one of he told me he was going to come. And I'm telling you, till today, sir, I've not seen him. I called, I sent text messages. It was actually frustrating, and it looks like we are not doing anything. And it forms a sort of delay in trying to meet up with the issue. So far, that's how we've gone. We hope with collaborations from very senior lawyers like you, BRIPAN, and various stakeholders like Security and Exchange Commissions, we will go far. Thank you so much, sir.
Thank you, Mimido. Mr. Kiyomi, if you look towards your left, you will see Vivian. She's also a staff of that unit, and she's also an associate of BRIPAN. So we continue to encourage all of them to partner with us for us to be able to ensure that that unit works for us. You know, it shouldn't be an academic unit. It should be a unit that improves insolvency resolution. The last man to ask a question at this session, please go ahead, sir.
Okay. Good afternoon, fellow delegates and the panelists. My name is Bashir Isa. I came all the way from Kano to attend this conference.
Welcome,
I'm
sir.
a lawyer. Thank you. My question is to Madam from the Insolvency Unit of the Federal High Court. Madam, we know that judges are always wary of and sometimes not wanting to at all grant ex parte orders unless it is absolutely necessary for them to do so. As lawyers, we get instructions from our clients as receivers. So mostly lawyers file applications in court at the Federal High Court asking for ex parte orders to enable them realize the properties involved. What is unit doing to sensitize our judges on the need for them to be accommodating lawyers in this regard? Thank you.
Okay, first of all, with regards to Federal High Court, you know, most times delays in hearing ex parte applications begin from assignment. And this is due to the fact that my Lord, the Honorable CJ, is a very busy person. And he hasn't given out powers expressly to who should assign those cases. So it causes a little delay until he's stable and able to do such assignments. And not to say it's an excuse, but he's actually assigning those cases, and he does them expeditiously the moment he sits down to do his work. So as soon as your applications are filed, I'm sure the judges will take up your matters. And then secondly, there's a trend going on of petitions against our judges. I don't know what is going on. So we are also, I'm not speaking for the judges, I'm just speaking out of the experience we have within the court system. A lot of lawyers are petitioning our judges. Okay, maybe they've heard such ex parte applications and granted them, and it doesn't favor the other party, and then they begin to petition. So we too are also very careful in listening to, our judges are also being careful in trying to listen to those applications, so we don't fall into the situation where we are being petitioned and taken all over. But I must ensure you that we will do our best. Thank you so much.
Mimido, please continue to do your best. And I think one of the things BRIPAN has been doing is improving or capacity building with judges. I know that on the auspices of BRIPAN, several judges of the Federal High Court have been involved in training, INSOL conferences, Africa Roundtable, and they see how important speed, efficiency in resolution of insolvency processes is important in commercial activity and also in a country becoming a place to do business. So we've met several of them in conferences in all across Africa and other parts of the world. So at this juncture, all that is left for me to do is to thank our distinguished speakers who have poured their hearts out as subject matter experts on various topics in this session. Firstly, I would like to thank Mr. Oluseye Okpasanya, Senior Advocate of Nigeria. Thank you so much for your agreeing to speak and speaking at this conference and your insights into your work as receiver of. I also like to thank Joe Michel Marias, FCA, who joined us from Japan. Japan is almost like 21 or 24 hours time difference from here, and she has stayed all throughout. Joe, we are very grateful. We thank you very much for speaking at our conference. Some of us look forward to seeing you at the Africa Roundtable in South Africa later this year. And thank you so much. We also would like you to join us in our future conferences. Thank you very much. We appreciate you. A big round of applause for her. Also, I'd like to thank Ms. Mimido Abako, Head Insolvency Unit of the Federal High Court. Thank you very much for sharing talking to us about the Insolvency Unit. We really appreciate the insights that you have given to us. And finally, before finally, I'd like to thank Mr. Olasoni, Associate White and Case LLP, who has spoken to us about how we have to adopt artificial intelligence in insolvency practice and processes. Ola, thank you very much. And we look forward to you joining us in our future conferences. Thank you very much for your time and your resourcefulness. We really appreciate you. I'd also like to thank the coordinator of this session, Cynthia Ekeka, Principal Counsel NULEX. Cynthia, thank you very much for holding us all together. We very much appreciate you. And I want to thank you all for your patience, for spending time with us in this session. And I hope that the speakers have been able to share some of the useful tips for you. We thank you so much for also attending this conference. This is our last session, and I'm sure that you've all had a good time in this two-day conference. If you have had a good time, say Gosa. Say another Gosa. Please let us give our speakers a round of applause again, and please give yourselves a round of applause. Thank you very much.
Thank you so much, Mr. Akintunde, SAN, for holding down this particular session. And he's already thanked all the speakers. I just want to reiterate a big thank you to all our speakers, Joe, Ola, Mimido, Mr. Obasanya. We really, really appreciate your time and efforts in making this conference a success. So we are going to be calling for a photo session now. I'll be inviting all the executives of BRIPAN, the CPC chairman, the president, the past ESCOs, the immediate ESCOs. Please join us on stage for a group photograph. Thank you so much. Now we move forward to the presentation of gifts, and I would like to invite Mr. Shola Oyetayo, FCA, the past president of BRIPAN 2015 to 2017, to present the gifts to the speakers. One by one.
Oh, that's a long time. Speaking.
Which one is this now? Oh, gift. On behalf of BRIPAN, I do present this to Mr. Olusegun Opasanya. Thank you very much. Who is this? Oh, Miss Mimido Abako. On behalf of BRIPAN, I do present this to you. Which other one? That's all? Okay. Hey, the chair. On behalf of BRIPAN, I present to Mr. Yodele Akitune, SAN. Chair.
Thank you.
That's all.
Thank you so much, sir. I'm over.
This plaque is becoming old-fashioned.
Okay. Thank you so much. Nice to have you.
All right, distinguished ladies and gentlemen, it has been a fantastic time here. Ladies and gentlemen, at this point in time, permit me to seize this opportunity to thank our diamond sponsors. We would really like to appreciate Zenith Bank. There's a reason why you are Zenith Bank. Would also like to appreciate FCMB. Thank you so much for your support. Would like to give out our gratitude to EcoBank, the Pan-African Bank, and would also like to appreciate Stern and Bland partners. Thank you so much for partnering with us. Would also like to thank AO2 Law. Thank you so much. And not forgetting Grant Thornton. Thank you, thank you, thank you. Would also like to say a big thank you to all our gold sponsors, silver sponsors, bronze sponsors, and of course everyone that has stood by us one way or the other. Without you, this conference would not be possible. Not forgetting Kristen Peterbo, thank you so much for your love and support. Distinguished ladies and gentlemen, it has been a very insightful and meaningful 2-day conference. A lot of conversations have started here in this past 2 days, but I also know they will not end within the four walls of this room. These conversations will go on and on until we are able to make meaningful changes that help bring our economy where we want it to be. All right, ladies and gentlemen, we know that BRIPAN is not all about the suit and the tie, right? And we like to party, don't we? I know they like to party. Don't pretend. Come on, stop that. You are beginning to pretend like you don't have a happy side. It's not just about the suit and all the talk. Tonight is going down. We are going to party tonight. All right? Ladies and gentlemen, join me welcome the beautiful lady to tell us about the gala night. DJ, do you have a small sample of the kind of song we're going to dance to tonight?
Hi, everyone. Good evening. So after this program, we need everybody to go out so I will do the decoration for the gala night. The gala night starts at 6, and everybody is expected to dress in anything Afro Chic Royal, talking about Adire, talking about anything, Akara, anything. Just bring out your traditional game and come here. We have palm wine, we have unkwobi, we have abacha, we have ofada, we have amala. Anything, we have everything. We also are going to be having the spoken words, we're going to be having the dance troupe. So it's just going to be a fun night. We also have the induction ceremony for those that are going to be inducted. So we're just going to have fun, basically. So we can't wait to have you at the gala night this evening. Thank you.
All right, in case una no understand wetin she just talk, we just want to let una know say party go day this night. You don't understand? The team now waiting Afro Chic Royal. Whether na chic, I been a shake. But ladies and gentlemen, bottom line be say, may you do it, may you wear your ashoke, wear your adire, Ankara, anything we get touch of Africa. For all those ladies, it's all right to bring sexy on, if you get what I mean. Basically, just look fly and look fine, but make sure you're comfortable to party tonight. Hey, the way this oga they look me, bros, you go come out tie. You go come out tie, you go leave suit for your room, for your hotel room, come out to party, to mingle. And hopefully we make meaningful connections after all the work. After all the work, Jack must play. All right, please join me welcome Mr. President. Sir, we're ready for you. President BRIPAN to give his closing remark. Ladies and gentlemen, please put your hands together, put your hands together, put your hands together.
Thank you very much. Thank you, thank you, thank you. Let me say that on behalf of the council and members of the Business Recovery and Insolvency Practitioners Association of Nigeria, BRIPAN, I want to extend our appreciation to every participant, every member that has made the sacrifice to stay on since yesterday up to this point. I'm very, very happy, and I must say that we have continued to grow from strength to strength. I also extend my appreciation to all our numerous sponsors that have supported this conference. I commend in a special way the conference planning committee, that at this point one can say, yes, it has been a very good, in fact, an excellent conference. So I thank the chairman, the co-chair, and the sub-heads of all our respective subcommittees under the CPC for doing a very fantastic job. Please, we appreciate you all. We thank the members of the press too, the media corps, for their efforts and making sure that at least this event will not go unrecorded. Distinguished participants, let me use this opportunity to remind you that our gala night today has been fixed to commence at exactly 6 p.m. Having stayed with us this long, please don't miss the gala night, because it's been packaged by the conference planning committee in a different way. I will also remind the committee in charge to continue to work hard. I know we have come to this point and it's been very successful. I also pray that our gala night will also be extremely rewarding for all the participants. Thank you. And as you journey back, we pray that God will lead you to your respective destinations. And we also pray that God will continue to bless you abundantly. And the final point is that the future of insolvency practice in Nigeria today is in our hands. Nobody will do it for us. So let us continue to work together to ensure that this space, the insolvency regime, continues to improve. And I assure you, it will not only benefit the individual practitioners, it will also benefit our dear nation, Nigeria. Thank you, and God bless you. Thank you very much. I forgot to comment Chioma. So please, Chioma, you have done very well. Thank you.
Thank you, sir. In fact, I wouldn't have gone home if I didn't get that commendation. I would have stayed in this hall. All right, ladies and gentlemen, my name remains Chioma Agunobi, and I must say it has been my heart is full of a lot of gratitude to every single person here today. Thank you for all the support. Without your support, I would not have been able to perform my duties as effectively as I should. On behalf of everyone here and the BRIPAN team, I'd like to thank the speakers, the panelists, the facilitators. Everyone brought depth and clarity and, of course, wisdom to the session. To our partners and supporters, thank you, thank you, thank you. As we leave here today, may we not see this as an end, but rather as the beginning of a new, renewed commitment. All right? And on this note, I'd like to say I look forward to being your host again come BRIPAN International Conference 2026. But until then, I wish you all a very safe travel back to your various destinations, and of course, a very fruitful endeavor and lasting success in the year to come. Distinguished ladies and gentlemen, boys and girls, the party is just about to begin. It's going to be the party after the conference. If you may please have your lunch and exit the hall so that we can tear down and rework the hall for the gala, which practically is our after party. Distinguished ladies and gentlemen, please leave the hall, go get dressed, and come back with your party spirits. My name is Chioma Agunobi, TV producer, presenter, and of course, MC. Distinguished ladies and gentlemen, the time for our gala is 6 p.m. All right, may we rise for the national anthem. Sound, please help us with the anthem. May we rise for the national anthem. May we rise for the national anthem. May we have the national anthem. Please put your hands together for yourselves. See you by 6 p.m. for the gala night. Please, owner of Toyota Highlander, olive green color with plate number EKY 547JV. Your attention is required outside. Thank you.